Yes.
Madam, I taken after 2 weeks, madam.
You're for the respondent?
No, madam, petitioner, madam.
Petition.
I have taken consent of the respondent, my lord.
Achha. Exercise is also there?
Yes, yes. I have informed them. madam.
With the consent of the other side. Wait for an adjournment. We are listing after 2 weeks, right?
Yes, madam. There's an interim order, madam.
Yes. Okay. List after 2 weeks as an entity fixed by history. Interim be continued next.
Obliged, lordship.
May I please your lordship? I beg to mention item number 19, your lordship, for admission. I'm for the petitioner and I have taken the consent of the other side. The other side have filed an objection. In this
I'm
case,
the respondent.
and the same is not on the record, your lordship. So kindly the matter may be checked along with the objection.
Lordship, if
So you
possible,
want
kindly.
call for take it today or you want an adjournment?
Adjournment.
Lordship, if
Up to
possible,
1 week.
kindly fix on 19.
No, on 38, the case is fixed. 38 May.
38 May where, please?
May in the lower
Where?
court.
Where? In the lower court?
Lower court.
She is seeking 19th.
No, it's on 30.
She is seeking 19 to be fixed today. Hear the matter.
On
Before the
19.
trial court, it
On
is on
19.
38. She is seeking then 19.
Okay, your lordship.
On the case. You are MS?
Your lordship, if I beg your pardon, can it be on 20, your lordship?
Just a second. Your name is?
Miss Arvega.
Her name is Arbet, counsel for the petitioner. We consent to the other side. She paid for an adjournment. Very, you are MS?
R. Khatun.
Very name is R. Khatun, appearing on behalf of Mr. M. Bora.
Yes.
Appearing on behalf of Mr. M. Bora. There is no objection. But it is submitted that you have filed your objection. Huh?
Yes, Lordship.
The
On 8
petition
May.
has already been filed. PST is accordingly directed to take the objection along with the statistics. Is the matter 20 will be possible on your part?
No, Lordship. If possible, kindly 26 or 28.
Not 28, then 21st, your lordship. Because my senior will be out.
25th of this month.
Lordship, if possible, kindly fixed on 26th.
What is the problem in 25?
Lordship, the learned council will out of the town.
Huh? Unlock?
25th. Okay, Lordship.
25th of this month.
Obliged.
Hello.
May it please your lordship, I beg to mention item number 17. Kindly
17?
1717.
Yes, you're for the petitioner.
Yes, lordship. Kindly pass over it for today as my senior Miss Tisho is out of station.
You are MS?
D. Basumatari.
Hard MS T. Pusmatari appearing on behalf of MST. So, paid for an adjournment stating that the NDS consent is out of state. The amount is 28th of this month.
Next.
Wait, please, lordship. Item number 41. Make a leave adjourn for the day only.
41.
41, lordship.
It is submitted also.
Yes, 41. What is the
Total
position?
charge sheet submitted also.
Are you on interim there?
No, lordship.
No. Then we are not going to give the matter. If you have anything else, anything want to submit your, then okay, then we can keep it on.
Actually, I am not the actual counsel. This Mr.
Achha.
MS Ahmed is the actual counsel.
Okay. Okay. Next week, 18th of this month.
Lordship.
The
Obliged.
request made by land council for the petition is
On behalf of MH Ahmed. On behalf of MH Ahmed.
18th.
May please, Your Lordship.
Okay.
So I am praying for short immediately in item number 21, admission matter, Lordship. Could it be posted after 2 weeks, Lordship? I have taken the consent of the Lordship respondent counsel.
Respondent council we have informed.
Yes.
Consent of the other side. Learning council Mr. Anderson paid for an adjournment. You want any fixed date or after 2 weeks?
After 2 weeks,
Date the matter be accordingly listed after 2 weeks as an date you fixed by the registry. Is there any entry?
No.
Okay, then be listing it after 2 weeks.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 18. I'm appearing on behalf of OS Manna. Lordship, as per instruction, we would like to withdraw this case.
You want to withdraw this one?
Oh.
Your name is here?
M. Begum,
You are M. Begum.
Oh.
Item number 18.
18.
R. Begum is there. Your name is not reflected in the cause list. What do you do? You are A. Begum.
M. Begum, appearing
Begum.
on behalf of OS Manna.
M. Begum, RMS M. Begum, appearing on behalf of Mr. Y.S. Mannan, done it for the petition. And it is submitted by MS Begum that as per instructions of their client, they want to withdraw the same as the petitioner does not want to press the matter further. In view of this, let the matter be accordingly disposed of on withdrawal. Okay, the prayer along.
May I please, your lordship? Lordship, item number 42, lordship. She was called for, but she did not receive the two. Kindly adjourn for the day, lordship.
42.
42.
Yes, what is the position of 42?
She did not receive it.
42, city not. Are you on interim there? Are you
No,
on
no,
interim? No interim? Because
Very
city
good.
not present. Should remind them. Yes, Goswami, when it can.
19.
90?
Yes, yeah. 26 then.
From where it has to come?
Borpeta.
Borpeta?
Lordship 22. 26, lordship.
26 will do?
No, lordship 26, our 8th lordship. 27.
Oh, Eid is there.
Eid.
Achha,
Okay then. 22, lordship.
22.
May I please, your lordship? Lordship, subject to my lord's convenience, my lord. Item number 32, my lord, charge sheet has been submitted, my lord.
Yes, have you information? 32. She has already submitted.
Yes, sir.
Are you
On
on
in-
interim?
Yes, my lord, I am.
Okay, then what is the CS number?
CS number lordship 295/25 dated 30/11/25.
Looks like 30. 30.
Item 30.
30/11/2025.
Lordship.
Mr. NVP Singh, the Learned Counsel for the petition. Mr. D.P. Goswami, the Learned Additional BP acting on state respondent trust number. It is submitted by Mr. Goswami that this case has already been charged sheeted by its CS number 295/25 dated 30/11. Again, so and so. So we are extending your interim of 15 days.
Obliged.
Ma'am, please, your lordship. I beg to mention item number 5, motion. It was earlier, it was called for your lordship, and interim is there, your lordship. I clear your lordship, password for the day, your lordship, any date, your lordship, and may kindly list it for delay.
CD is available.
For that, your lordship.
Why it is in the motion column that CD? It's a wrongly listed.
Wrongly.
Heard Mr. A. Arpani, the Learned Counsel for the petition. Also heard Mr. A. Sharma, the Learned Additional BP appearing on behalf of state respondent. Submitted by Mr. Arpani that some personal information needs an accommodation prayer allowed. However, it is submitted by Mr. Sharma that CD has already received. You're going to retain the CD? Your interim is there. Next week.
It is available.
18/5.
Interim may continue.
18/5 going to interim be continued till next set of listing. Further registry is directed to list the matter in the hearing.
May it please, your lordship, I beg to mention a listing of a IE in anticipatory bail application, your lordship. IE is for the correction of the
Make
order.
okay, I can understand it is for correction, but till then, in spite of that, you have to either make it mentioned before court number 8. Court number 8
Your
or
lord,
before the registry.
your lordship has passed the order.
Yes, I understand.
Okay.
But still, you have to mention. It will come before this court.
Oblige, your lordship.
May it please your lordship. Lordship, I am appearing for item number 60.
Item
Lord,
number
60.
16. 60.
Yes, Lordship. Lordship, we want to take 2 weeks' time. We were asked to file additional affidavit to bring into records all orders, but we could not procure the same through, though we have applied for it, Your Lordship. So a date may be fixed after 20 May, Your Lordship.
Your good name?
Udyan Bhattacharya.
Your name is not here, na?
No, I am appearing on behalf of my senior Dara Kulla.
But Mr. U. Bhattacharya, the learned counsel, appearing on behalf of Mr. D. Ulla, the learned counsel for the petition. And submitted that they need 2 weeks, some more time to file their additional affidavit to bring some order sheets on their allowed. Yes, when do you want? After 1 week?
After 20 May, Your
After
Lordship.
20 May. 25th of May.
Most of that.
May I please, Your Lordship? Lordship, I beg to mention item number 55. Lordship, finally adjourn this matter for the day.
Orders.
This may be done in course of the petition. Matter is adjourned, the matter be accordingly listed. After 2 weeks will do. Now you want any date?
June, first week of June, Lordship.
First week of June. Okay. 3rd of June.
May I please, Your Lordship? With respect to item number 22, Lordship, I may be allowed to withdraw the petition, Your Lordship, as per the instruction of the client.
22.
Yes, Your Lordship.
You are MS?
L. Wangsa, Your Lordship.
That's hard MS and Wangsa did done it. The petition. So part Mr. DB Swami did done it additional PP appearing on behalf of James Bond. Stop it is submitted by MS Wangsa that as per instructions of the petitioner, she wants to withdraw the same. As the petitioner does not want to raise the petition, raise the matter, but in view of this prayer allowed, the permanent petition is according to the scope of
Obliged.
May I please, Your Lordship? I beg to mention item number 35. Your Lordship, I am on interim. The engaged counsel is out of station.
Yes, what is the position of 35 Usami?
We have not received the case, right, Lordship? Yes, no, I think employment.
You have not
Yes,
received the case.
we are
then.
in.
She did not receive, should remind. Yes, Usami, when it can be. From Mukalmo, 25th. List on 25th, so and so interim be continued till next day.
Obliged. Lordship, the matter may can be taken after some time, Lordship.
Okay. At this state, my lord, PCR may be called for, my lord.
PCR.
My lord.
Is a charge sheet case?
Charge sheet case, my lord, trial is pending, my lord.
TCR be called. Scan copy of the TCR be called. Registry will routine it to. Registry matter. It has to come from which place?
Special just Kamrup Metro.
Kamrup Metro.
My lord.
25th of this month.
Earlier.
May I please, Your Lordship?
Yes.
This is regular bill application, Lordship. And FI will find page number 13, Lordship, particular Lordship, very short FI, Lordship. Particular Lordship, page
Yes.
13, 1-3.
Hmm.
May I read, Lordship?
Yes.
সন্মান সহকাৰে ক'ব বিচাৰিছো যে বশিষ্ঠ অঞ্চলৰ আৰ্ট কলেজৰ সন্মুখত অৱস্থিত মোৰ দোকানৰ পৰা যোৱা 4 দিন ধৰি এজন লোকে দোকানত অবৈধ প্ৰৱেশ কৰি ব্ৰইলাৰ মুৰ্গী চুৰি কৰি আহিছে। একেৰাহে এই ঘটনা হৈ থকাত প্ৰায় 10,000 টকাৰ অধিক ব্ৰইলাৰ মুৰ্গী চুৰ হোৱাত যোৱাকালি মৌখিকভাৱে আৰক্ষী বিষয়াক জনোৱা হৈছিল আৰু কৰ্তব্যৰত আৰক্ষী বিষয়া উক্ত স্থানত প্ৰত্যক্ষ কৰি আহিছে, কিন্তু যোৱাকালি ৰাতি পুনৰ চোৰজনে চুৰ কৰিব আহোঁতে স্থানীয় লোকে প্ৰত্যক্ষ কৰে আৰু ইমান নম্বৰ গাড়ীৰ বাইক এখনেৰে ল'ৰাজনে চুৰি কাৰ্য সংঘটিত কৰিছে আৰু আজি ৰাতিপুৱা হাতেলোতে কৰায়ত্ব কৰে। So, my lord, in this case, nothing has been recovered from his lordship and possession lordship. And in my petition lordship, para number 4, and he is working in a lordship boiler farm lordship for last 10 years, and he is a delivery delivery boy has come driver lordship. So, my lord, there is some dispute with the informant lordship, and he has the boiler shop lordship. And some collecting some money lordship dues in this regard lordship, there is the dispute lordship. But otherwise, he never stolen any chicken or something else lordship. So apparently lordship kindly come to lordship forwarding report page, sorry lordship, seizure list page number 20 lordship 20. 20. So lordship, and place of seizure Bokhisto Mandir PP and so there is nothing lordship. Description of seized documents and articles lordship. One FZ Yamaha motorcycle and 1 keyboard. There is nothing lordship. So, my lord.
Now, see, obviously there will be no the broiler chicken will be there because earlier he used to do on that day, very day he was caught red-handed while he came for stealing those this chicken and all. So now that is the issue. That's why those are not with them. But obviously he got arrested on 13.
One lordship.
Yes. It is from Bosishta. Okay, when it can be
18th.
18th. Or is also Mr. Hawkins.
Lordship. But here in this case, only 2 number of got lordship, and the petitioner is a driver lordship, already recover spot lordship. 2 gots only. And lordship kindly come to FR lordship and page number 9 lordship. Type code. May I read lordship? With due respect, and honor would like to state that I, Sri John Kolita, Jyotish Kolita, so, and wise to lodge an ezaher against the god theft on so and around so. On the said date, 2 unknown people forcefully pick up a god from a national highway of Bortespur in swift car so, and on one thief was caught by public in the Rampur with 2 gods inside the car and one area away from the place, and 1 black goat and khashi was found inside the car, whose market value about 10,000, and another white female goat of Gita Kolita so and which was market value 8,000 lordship. It's for takeover lordship, but nothing lordship, and he is the driver.
That's simple. Case number, what is the case number?
Case number lordship, Polasberry PS case number 102/2026 under section 303 section 2.
Case number 104.
I want to figure only 2 goats. It means from where it was stolen. If a farmer only 2 goats for our farmer is very huge. If a goat was from a farmer or other poor person, then it was the use loss for his stuff. Only 2 goats doesn't mean lot.
See, spot recover lordship and 2%. FI itself is clear lord. Lordship, another submission lordship, 1 co-accused lordship appear will grant lordship by your lordship.
This will be covered. Right, we get it. within. Other case is fixed on 28 because he was not caught red-handed. Your one is caught red-handed. That is the difference. So you got arrested on 1/5. Other matter just I have checked.
Look.
It is fixed on 28. So
Look.
it will be late for you. I think.
Look,
So
I-
we try to give a shorter date.
15 lordship entities from
15
Poland.
may not be possible. It may come, I don't know, 55. Both matters are
18 or 19?
18th.
I'm sorry, lordship. Can it be lordship? 19 lordship.
18.
19.
18 will not be available.
Lordship and some difficult lordship. 19.
Okay. Okay.
6.
Your lordship earlier rejected matter. I want to appeal to this time at this stage.
Highly rejected one. Yes, Goswami, when it can be called.
Yes, sir.
25th lordship.
25th ago,
22nd, 22, 24.
22nd. And updated CTP called 22nd.
up to
Okay,
date.
by listing it on updated city is called for on 22nd.
Obliged.
7.
May it please your lordship. As an anticipatory bail application, the lordship will find the FIR at page 9, madam.
Each 9.
Page 9, madam.
Yes.
May I read the FIR, madam? Sir, it is humbly submitted that I am a permanent resident of the aforementioned address and I am an Agarwood businessman by profession. On 29 December 2024, the accused person number 1, Bodrul Islam, madam, this is the petitioner, madam, purchased Agarwood from me worth rupees 12 lakhs. Accused person number 2, so-and-so, was actively involved in the trade as an agent of accused number 1. As per the terms of the agreement, they were supposed to pay the entire amount within 15 days. However, even after 2 years, they have not paid the money. When I went to the house of the accused person demanding money from them, they have threatened me by saying that they would pour petrol on me and burn me and also threatened me with a gun. These threats have put me and my family member in great mental pain. The accused persons have for many years in a similar manner been purchasing agarwood from many small traders in Hojai district and looting their money by breach of trust. For example, from Kausar Alam, 7,15,000, Nizamuddin, 26,42,000 and Ajmal Haq, 18 lakhs. These victims mentioned herein are ready to become witnesses before the police. It has come to light that they have done such breach of trust worth crores from various parts of the district. The accused persons have cheated and are criminally intimidating me and other traders. And we'll see the prayer. It is therefore, does it is prayed that immediate action may be taken against the accused persons and arrest them and recover 12 lakhs for the end of justice. So effectively, this is an FIR. They have sold the goods. They, as per the informant, he has not received the dues. He has lodged this FIR seeking the recovery of this money. So, this is a case which is clearly covered with the Sales of Goods Act. For this, the correct remedy for him would have been to file a suit for the recovery of the money. So it is our contention that we have paid the money to this person. However, in business, some transactions, some payments may get delayed from time to time. This person has been doing business for more than 10 years now. So whatever be the grievance of the informant, the correct procedure was for him to file a suit. Instead of doing that for recovery of the money, this criminal prosecution has been initiated.
Yes, but the question is that it is okay. Money transaction was there and it was the case for recovery of money. But apart from that, there are allegations that you are doing these things to many others.
That is their allegation, my lord. But these persons,
that being this so, then you have some criminal intention, obviously.
But I have no criminal antecedents. No person has ever come forward other than this person to lodge an FIR against me.
But there is a list.
They have given a list, my lord. That these persons have, I have also not paid money. My lord, assuming that this is correct, my lord. I am a businessman. I have been doing business in that area with several people, my lord. Now, assuming that these persons are, that it is correct, my lord. Though we are categorically denying this allegation, my lord, but assuming it is correct, my lord. Even for these persons also, the remedy would still be a civil suit and not a criminal FIR matter. If I have sold the money, the Sales of Goods Act has been enacted for this purpose. If a movable property has been sold to a person and that person has not paid the money.
There is a provision. I won't deny it, but that's what the other allegations are. Yes, Mr.
At least case line may be called for after because many persons.
Whether this is cheating or not, my lord, that is the whole issue. Because if I don't pay money, then every loan transaction where the person defaults in payment of money, then he becomes a cheating. But that is not the ambit of cheating, my lord. Assuming this is correct, my lord. Suppose CD also comes and this is found to be correct, my lord. Even then, he should go to a civil court, my lord.
This is lordship, I pray for only case diary.
Yes, the was done. Heard. Mr. DP who submitted and it's an application. Expressed submitted by Mr. Hawan on the plain reading of the FI itself. It is seen that it is a case. But there was some money transaction to the business purpose. And the allegation that the present petitioner had not returned the entire amount of money to the petitioner, to be informed. Accordingly, he submitted it is a clearly a civil dispute wherein the petitioner could have approached a civil forum on the so-called act or recovery of money, and there cannot be a criminal case where allegation however, the is required to extend their cooperation in murder investigation case. It is granted with cemetery. Next, Mr. People submitted that there is education of cheating and the entire fact will be revealed on 12th of the step. Mr. accordingly insisted all for the case. Next, for hearing the submission made by the and the nature of application. This code is open and information may be provided the present petition so that we can submit and cooperate with the discuss. Okay, you'll be under interim petition, appear before the IF.
I'm deeply operated.
Usami, when it can be? 26th. You give a first week of June then.
Lordship granted the intent protection.
Yes.
But then first week of June, lordship. Do not. Fourth of June.
I'm deeply operated.
May it please your lordship. Lordship, anticipatory bail application. FIR is at page number 8 here. May I read the FIR? Page number 8, your lordship. Sir, with due respect and humble submission, that while I was sleeping, some unknown persons entered into my room and committed theft. It is worth mentioning that yesterday after sleeping, when I woke up at 6:30 a.m. morning and I found that door of my bedroom and Godrej were open, after that I came to know that the below mentioned articles were stolen. I am requesting you to take necessary action. This is the FIR, your lordship, where nobody was named as an FIR named accused in the month of August 2025, your lordship. Thereafter, your lordship, the present petitioner here, in these details of articles, there was one mobile phone which he purchased as a second-hand mobile phone, your lordship, in the month of around January, your lordship. After he had turned on that phone, then it came to the light of this accused person that the person who sold him the phone, and the entire story is that this is that particular phone which was stolen in the month of August, your lordship. Thereafter, your lordship, police went searching for him, and therefore he's ready to submit the phone and include all the details from whom he has purchased the mobile phone and all other applications. May I be protected, your lordship? I'm ready to willingly appear and record my statements whatsoever. I am not the person who has directly conducted the theft. I purchased a mobile phone, which is this particular mobile phone.
Yes.
From where he has purchased the mobile phone, that was to get certain because mobile phone was recovered from his possession. So at least
I'm ready to submit the mobile before the police also, your lordship, and everything in detail, your lordship.
Your good name?
TL Oscar, your lordship.
Yeah. Name is not reflected.
Oh, your lordship.
Your name is not reflected here.
Your Lordship, one of my friend, he is unable to attend the court today, engaged counsel, Your Lordship, H. Huda, due to H. Huda, Your Lordship, due to his extreme ill health, and therefore I am replaced.
I, Mr. T. Nasrani, appearing on behalf of Mr. Huda, learned and his counsel. And also by Mr. D.P. Uslam, the learned PF. This is an application section submitted by Mr. that the present application he has not moved it inside office. However, it is a fact that he purchased the mobile handset. Second-hand mobile handset from a person in the month of January 2026. And when he turned on his mobile phone, police was in search of him, and that only he came to know that the same mobile phone is stolen. He handed over the mobile handset. And the apprehending arrest in connection with this case. Some interim protection may be provided to him so that he can appear and can cooperate with the investigation. Next, Prime Minister submitted that CD may be called for the state to not be actual track. Expert hearing this submission by plan and size. Considering the submission made by for the petition and other aspects of the case, this court is of opinion that interim protection can be provided with the petition till the receipt of the case. So it's okay, you'll be under interim protection.
Deeply obliged.
On another submission of my security. After treasure of that case, I'm prior to the on sufficient materials. That's why
Mr. Further submitted that the learned track would be located earlier rejected his bail compared to the case state. It must be right. Yes, when it can be 5th of June. 5th of June.
Deeply obliged.
May I please the law? Here, my lord, the petitioner, my lord, is a class 1 contractor, my lord, and some financial dispute is going on with informant, my lord. They have filed an FIR before the Proceedings police station. GT&T was made, no formal FIR has been registered, but without registering case, my lord, and without issuing any notice, the IO of the case, my lord, frequently asked the petitioner to appear, my lord. Then, my lord, we made inquiry, my lord, whether case has been registered. No case has been registered, but he was insisted to appear. So I am apprehending, my lord.
Yes,
regarding the any FIR registered against the petitioner or not.
it would be in Bosista.
Position.
Petition. Mr. D.P. Goswami, yeah. This application is for it to be for anticipatory bid. Next, right, submitted by Mr. Ali that the present accused petitioner has some business transactions with the informant and but on the in the or on the same but on the same context, the informant logs a complaint, and on the basis of which Bosista police station GD entry number 1228/26 has been made, and without registering a case or even without issuing a notice to the present petitioner, police is harassing and searching for him, and for which the present petition has been filed seeking some information. However, the petitioner is ready and willing to extend his cooperation in the investigation of the said case. Next, Mr. Kusami, the learned submitted that he will take instructions as to whether any case has been registered under Bosista police station case number in reference to GDE number 1228 of 2026. Hearing the submission made by learned counsel for consents, let the police report be called for from Worcester police station as to whether any case has been registered against the present petition. And police from the Worcester police station is hereby asked not to take any corrosive action in receipt of the report. When it can be
Next.
20.
Next week. 22nd.
22nd.
But in the meantime, no coercive action.
Yeah, on it first.
Obliged.
Yeah, please, Your Lordship. It's the second bail application. Earlier, it was rejected on 16/3/2026.
Earlier it was rejected on 16.
16/3.
16.
FIR is at page.
Where it's still under investigation matter is?
Yes.
Not yet charged sheet.
No.
So
No,
if
FIR
earlier rejected, then definitely we have to call for the updated one. Case diary. From where it has to come?
Borpeta.
Borpeta. 26th of May will do. Updated case diary be called for. Okay.
Much.
May I please, the Lordship?
Yes.
My Lord, this is a pre-arrest bail application, my Lord. The affair in which we are seeking bail, my Lord, may be pleased to turn page 18. My Lord. I'm troubling my lordships with the vernacular, my Lord. The translation appears to be a little bit, my Lord, by one of my colleague, my Lord. Proti manoniyo bharprapto
When is the translated one?
my Lord, is at page 20.
20.
Is the vernacular and the translated is at page 18, my Lord.
20 is the vernacular.
My Lord, if my Lord allows me, I can read the vernacular, my Lord. প্রতি মাননীয় ভারপ্রাপ্ত বিষয় মহোদয় শুৱালকুছি আৰক্ষী থানা স্বয়ংস বিষয় এজাহাৰ তাৰিখ স্বয়ংস গুচৰীয়া পূজা দাস স্বামী স্বৰ্গীয় শম্ভু দাস সহকাৰ গুৱাহাটী তেতেলীয়া পৰিচয় স্বয়ংস কণ্টেনশ্যন ইজ ডেট মহাশয় শ্ৰদ্ধা ও সেৱা গ্ৰহণ কৰিব সন্মানপূৰ্বক বিনীত নিবেদন এই যে উপৰোক্ত 1 নং পদকীয়াই মোৰ ভাইটি লক্ষ্মণ দাস নৱম শ্ৰেণীত উত্তীৰ্ণ হোৱা চাৰ্টিফিকেট আনি দিম বুলি মোৰ পৰা নগদ 20,000 টকা লৈ জাল চাৰ্টিফিকেট দিয়ে আৰু উক্ত চাৰ্টিফিকেটখন জাল বুলি মই গম পাই উক্ত 1 নং পদকীয়াক উক্ত টকা বিচৰাত মোৰ ভাইটিক পদকীয়াগণে মাৰপিট কৰে আৰু মোৰ স্থগিত ৰাখে মিলক গতিকে দয়ালু মহোদয়ক বিহিত ব্যৱস্থা ল'বলৈ কাতৰৰে প্ৰাৰ্থনা জনালো My Lord, may kindly note that this is one FIR by Pooja Das, and the allegation is particularly against my Lord, Pankaj Nath and Jolly Nath, my Lord. And the petitioner, who is now before my Lordship, is Pradeep Vaishya, my Lord. My Lord, what has happened? Responding to this FIR, another cross FIR had also been filed, my Lord, by the parties involved in the earlier incident. My Lord, may be pleased to find that FIR is at also page 25 and the vernacular, my Lord, is at page 27. Page 27, Gusorio Jolinath, Shraddha O Hewa. My Lord, kindly turn to page 27, my Lord. শ্ৰদ্ধা ও সেৱা গ্ৰহণ কৰিব সন্মানপূৰ্বক বিনীত নিবেদন এই যে উপৰোক্ত গুচৰীয়া আগৰ চিনাকি হোৱাৰ হিচাপে আমাৰ ঘৰলৈ আহি বিভিন্ন ধৰণৰ কথা কৈ তৰ্কবাদ কৰি মোক মাৰপিট কৰে আনহাতে মই মদাহী ও গৰ্ভৱতী মই 3 মহীয়া গৰ্ভৱতী মাৰপিট কৰাত মই পেটত দুখ পাওঁ গতিকে দয়ালু মহোদয়ে ইয়াৰ এটা তদন্ত কৰি বিহিত ব্যৱস্থা ল'বলৈ কাতৰৰে প্ৰাৰ্থনা জনালো উল্লেখ থাকে যে আমাৰ ঘৰৰ গডৰেজ খুলি লাগতিয়াল নথিপত্ৰ লৈ তেওঁলোকৰ AS01GJ1050 নম্বৰৰ স্কুটিখন লক লগাই পলায়ন কৰে So, my Lord, there is a FIR and cross FIR amongst the parties involved therein. Now, my Lord, the police had started the investigation and fortunately, my Lord, one Caesar list they could prepare at page 29, annexure 3 is the Caesar list, my Lord. And my lord, in this Caesar list, I straightaway draw my lordship's attention to the description of the Caesar article. One school certificate in the name of Sri Lakshman Kumar, son of so and so of Kamrup. His date of birth is so and so, issued by the headmaster of SRDT Girls High School on dated 2/8/2021. My lord, I am a headmaster of a girls' school, my lord. And admittedly, I am a headmaster of a girls' high school, and the my lord may kindly see that this certificate had been issued in the name of Sri Lakshman Kumar. He is a my lord male. So, my lord, the issue now, as this my lord, my school's name has been reflected, and I am being the headmaster of the school. Now, the police is want to interrogate me and summoning me, and to that effect, my lord, I have stated in my paragraph number 5 also, my lord, in my petition at page 5, that the police has already ringed me in my private phone and want to interrogate me. Regarding that, my lord, I am going to cooperate with the police also, my lord. And I will tender, my lord, all my assistance to the police also. My lord, may if my lord is pleased, my lord, call for the case diary, my lord, and in the interim I may be protected, my lord, because I am no way involved and don't know anything regarding the case, my lord. Only when this Caesar list and the police call me, I have come to know, my lord. That is my case, my lord. And as the case is also relates to, my lord, documentary evidence, my lord, if something is required, I think, my lord, custodial, without taking me into the custody, I can cooperate with the investigation as a whole, my lord.
Yes.
The earlier FIR also, it was very reflected the certificate was fake. So certificate, whether the certificate was issued by the petitioner or not, the explain by case diary. By particulars, but on the case, yes, he clearly mentioned that it is a fake certificate. After confirming that the fake certificate was provided to him, that after giving 20,000 rupees. So he must have the school that it is not.
Allegation is not against me that I have taken 20,000 and issued a fake certificate. Allegations is against some other person, my lord. Even then, my lord, as my name, my school's name has been come into play, my lord. Obviously, police want to interrogate, and I will cooperate with all the assistants, my lord.
That this Lakshman is also accused in any other case.
My lord, that
probably.
also I don't know, because in the second FIR, my lord, it has not been not named, my lord. The Pooja Das and Indreshwar Das is the name accused in the second FIR.
No, why I'm asking?
My lord.
Because they need a certificate from school.
My lord.
Class 9 pass certificate.
My lord.
That may be required in connection with some criminal matters also. No, that
Maybe.
you are not involved. That's what I'm saying.
My lord.
That's why, man, that so urgently they require a
My lord, if case diary comes, I think everything can be find out, my lord.
Mr. Here, senior advocate assisted.
S. Abdullah.
S.
S. Abdullah.
Tahbildar.
S. Abdullah.
Abdullah, my lord.
Oh, S. Abdullah. Oh, sorry, your name is here. S. Abdullah. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on it's an application submitted by Mr. Puya in Senior Council that the present petitioner is no way connected to the next office. Wherein it is alleged one fake certificate was issued by certificate was issued, which was handed over to the informant by taking rupees 20,000. In that conflict on cross is also lost by the informant of by the accused number accused against the informant side. However, he is not connected with those FIRs. But as the certificate was stated to be issued from his school, wherein he is discharging his duty as an headmaster, the police is searching for him, and for which some interim protection is required, so that he can appear before the investigating officer, can cooperate in the investigation of this case. Next paragraph, Mr. Goswami, the learned submitted that Siri will reveal the actual fact of the case and the involvement of representation. Next product, considering the submission made by the counsel for good sense. And the materials in the case report. This court is of opinion that interim protection may be provided to the present petitioner till reciprocal instant. So and so, so and so. Okay, will be under interim protection.
My lord.
Yes, when it can. 4th of June.
Obliged, my lord, deeply obliged.
Well. May it please your lordship. Lordship, in this case, lordship, co-accused case has been disposed of by the Honorable Justice P. Pranjal Das, lordship. Whether lordship will take up this matter or not, lordship.
The state court is available.
Yes, lordship, in division bench and single bench they are taking.
Bench. Second, Sanjay Kumar. Oh, yes. Single is he is taking single in every day or
Today, lordship, I found lordship
He
two
has
matters listed before the court. Lordship.
whether we can fix the date because I don't know the single bench.
Yes, lordship, list showing supplementary list is showing lordship two item is fixed today also, lordship. In that court, lordship. If possible, lordship, let the matter be fixed today, lordship. Because
Today?
lordship, yeah. Because lordship, track record they have said, lordship, otherwise these petitioners are not named in the case, lordship. The person whose bail has been rejected, lordship, he was named in the FIR, recovered, lordship.
Item number 12. Mr. B. And considering the submission made by Mr. Chaudhary, let the matter be listed before appropriate bench. Registry will do the needful. Day after tomorrow? Day after tomorrow.
Can it be tomorrow, lordship? Can it be tomorrow? Because it's wrongly
Not
listed.
in a position to say anything. Yet your submission only whether he is
Lordship,
taking
track
single
record
bench
is there,
every day or some particular day because he is taking division bench. Na? That's why we are saying that he is saying that till tomorrow there's no single bench is showing. So if you fix it on day after tomorrow, that in that case it may be listed.
Okay, lordship, I'll leave it.
Day after tomorrow. Day after tomorrow means Monday. Get there tomorrow. 13th of this month.
Obliged.
Yes. Yes, 13.
May I please, your lordship, 482 application, your lordship. The FIR is at page number 105, your lordship. This is a supplementary complaint, your lordship. Subject is supplementary complaint in continuance of FIR dated 1/2/2023, your lordship. And this FIR dated 1/2/2023 was never registered, your lordship, which is at page number 97, your lordship. It was never registered because the dispute between the parties is civil in nature, your lordship. What has happened, your
First
lordship?
one is on 95.
Your lordship, 95, 97, your lordship. This was never registered, your lordship. Dated 1/2/2023. I will give a brief of the case, your lordship, in short, your lordship. The informant and the accused persons are relative, your lordship, and all are legal heirs of one Bolendra Kumar Bora, your lordship. The informant has filed a title suit against the accused persons. The accused persons have also filed a title suit. Same are pending, your lordship, before the civil court, your lordship. And the present accused, who is a accused number 10, your lordship, he is pro forma defendant in both the title suit, your lordship. No claim has been sought from the pro forma defendant, and who is a accused number 10 in this application, your lordship. I was arraigned as an accused and also I was arraigned as a performer defendant just because my father drafted a will which is a matter to be decided by the civil court, Your Lordship. Now, Your Lordship may see the present FIR 105.
So what is the position of the earlier FIR when it was
This was not registered, Your Lordship.
not yet registered?
Not registered, Your Lordship. The earlier FIR was not registered, Your Lordship, because the matter was civil in dispute, and this present FIR was addressed to the Superintendent of Police, Your Lordship. Therefore, without preliminary inquiry, this FIR was registered under IPC, Your Lordship. And the allegation in the
No, earlier was not registered.
Not registered.
Now the continuation is registered.
Registered, Your Lordship. And it is registered under IPC, Your Lordship. It is registered on 23/2/2026, Your Lordship. Lordship may see the FIR, Your Lordship. Accused number, my accused is at page number, Your Lordship, 108, Your Lordship. Dr. Isankur Soikia, Lordship. He is also a professor of Gauhati University, Your Lordship. Relationship nephew, place of civil proceeding, defendant number 36, defendant number 3, Your Lordship. Your Lordship. And the allegation is also for the my present accused is at page number 112, Your Lordship. Entire FIR is the brief of the civil dispute, Your Lordship. 112, Your Lordship. On so and so certain family members created a Kusum bill in the charitably trust, Your Lordship, with an initial corpus of 12 bigha drawn from our ancestral land. So these were the allegations, Your Lordship. And page number 113, Your Lordship, at serial number 15, in title suit number so and so, accused number 1 and 9 falsely claimed that the trust was formed with my knowledge, Your Lordship. So these were the allegations, Your Lordship. And the entire matter is civil in nature, Your Lordship. And the prayer portion is at page number 116, Your Lordship. Prayer is, Your Lordship.
The earlier FIR when you have listed 97, page number?
97, Your Lordship. Page number 97, Your Lordship.
Was not registered.
That was not registered, and I was not named also in that FIR, Your Lordship.
It was addressed to, it was that was also addressed
At
to
the Superintendent of Police, Your Lordship. That time it we were
But
called,
how can you say that other one is, the earlier one was not registered? Because it is the continuation.
Lordship, as per my instruction of the client, clients were called for at that time, statements were recorded, Your Lordship. Thereafter, nobody pursued, Your Lordship, because the matter was civil suit was going on, Your Lordship. And the prayer also says, Your Lordship, that summon and interrogate all accused 1 to 10 regarding concealment of my existing from purchase and from the relevant authority, suppression of actual land. So these are the prayer which has to be decided by the civil court, Your Lord.
Seems to be. Yes.
Allegations are only a lot. Yeah, allegations are there. That's why the complaint also. Because they have Indian constituency, Bob part was there, also, state part also there. That's why we also can see so going is there, what is the investigation stage of the case of it. We cannot assign anything not present to the.
I'm a government employee also, Your Lord.
All the things they want the involvement and role of the institution.
Because the basis is the civil suit, Your Lordship, and which is pending, Your Lordship. And for the accused number 10, he's not a plaintiff or a defendant in the civil suit as well. He's a pro forma defendant, Your Lordship. No claim has been sought from the pro forma defendant. And at page number, it is also stated that at page number, Your Lordship, 112, Your Lordship.
Mr. S.A. Said on the petition. Also, Mr. D.P. Goswami did an additional PPA on it. files an application under section so and so in connection with so and so. Next paragraph is submitted by Mr. Hussain, the representative petition is no way involved in the alleged offense. Rather, he post further, there was a civil suit is pending before both the parties, and as per the information, the earlier FIR which was lodged before the superintendent of police is not yet registered, but the present FIR, which is a continuation of the earlier FIR, has been registered, and the present petitioner is searching by the if further submitted that the civil cases which are pending between the parties, the present petitioner is shown as a pro forma dependent, and no relief has been claimed against him. Further, he submitted that from the in reading of the present FIR of the continuation FIR also, it is seen that it is a purely a civil dispute wherein some civil remedy has been paid for in the present case also. However, the petitioner is still ready and willing to extend his cooperation in the further investigation of this case if some interim protection is provided. Next problem, Mr. Goswami did an raise objection, submitted that there are some criminal allegations also brought against the present petitioner, and CD will reveal the actual facts. Mr. Goswami accordingly insisted. Next, hearing the submission made by considering the matters in the case and also the nature of the litigation. From this court is that interim protection may be provided till receipt of the case time. Accordingly, it's okay, you will be under interim protection, appear before there were some conditions abided by all the
Must have been
86. Well,
86.
86. 86.
Must have been.
My lord, FIR is at phase 11, my lord.
Wait,
Allegations are
wait,
11.
11.
11. Handwritten, I'll read from here only. And lordship, the allegations are under section 75(1) Roman 2, 75(1) Roman 4, and 79. In this section, 75(1) Roman 2 punishment is 3 years. 75(1) Roman 4 punishment is 1 year, and 79 is again 3 years. So, my lord, all below 7 years. He could have been given a notice and he could have let go from the police station itself. Unless Kumar judgment is very much there, up to 7 years, notice has to be given. Now, this one girl is there. She allegedly she's saying that she works in his shop, and then he had spoken something which he did not like, and she is saying is sexually oriented remark. And there is no allegation of any touching or nothing. Only he said something. And this, what happened, my lord? This girl was sent to my shop by one of my friends. Entire it was a planning. And now she says that he asked me to take one underwear from the shop. And he told me that then I tried it. Then he told me that whether it fits or not, show me. That much only. My lord, this is very vague. Nobody tries an underwear in a shop. That cannot be believed at all. Moreover, my lord, I'll read the FIR, my lord, and for this, my lord, today is 26 days, more than enough. Now, my lord, if lordship calls for CD also, these things only will come. Kindly, I'll read the FIR, my lord. Respected sir, madam, I so and so would like to lodge a formal complaint against my boss, Prakash, owner of Vanity Care of Bhrigu Market, Ganeshguri, Gauhati. I have been working in this shop for the past 11 days. This to be noted, my lord, for the past 11 days. On today, while I was at work, my boss Prakash told me to take a underwear item as Bihu gift from his side, from the shop. After that, I took and going to changing room and wear it. Then when I came to the shop, he is asking me to open the top and show him the fitting of the underwear. Therefore, I request you kindly take a legal action against accused and ensure that justice is served. I am ready to cooperate with the investigation and provide any this no. Very vague, my lord. And these shops, my lord, Vigu market, Ganeshguri Vigu market is well-known market. All shops are open. They have shutter. At night they put down the shutter. Entire shutter is open. And changing rooms are small changing rooms. Nobody tries an underwear. Entirely framed. Now, my lord, going to the allegation, why I'm asking for a bail today, my lord, because all 3 years. And he only said, if at all her allegation is to be believed, so he said that you show me the fitting. Only that much, no touching, nothing, my lord. What else needs to be investigated, my lord? 26 days they have taken me behind the bar. Now, further custodial detention, my lord, the face of it is not required, my lord. Kindly allow me to go on bail, my lord. Victim statement is this only, my lord. No touching, nothing. No, my lord. First day they filed it, my lord. While on immediately on appearance they have filed. That's why, my lord. My lord, only this much. And my lord, at all, my lord. Kindly see the sections, my lord. One is 3 years. Second one is 1 year, and third one is 3 years, my lord. 26 days, my lord, for 3 years punishment, my lord. This can be allowed, my lord. Unnecessary, my lord. He is behind the bar, my lord. My lord, these are the cases, my lord, which can be allowed, my lord. That's what is my humble submission, my lord. Otherwise, my lord, we never play like this. Lordship knows, my lord.
Then submitted that some big petitions brought it's submitted that for the election. No, but they submitted that in the plotted right, but cannot such paper as Alice here. If I submitted the only allegations with the all these sections which has been under which the case is registered is at best punishable for 3 years, but at the time of his arrest, no notice was given. Section 3. But the petitioner is in custody since last 26 days, and hence, considering his length of detention, he may be released. But the petitioner is still ready and willing to extend his cooperation if required in further investigation. Next, Mr. Kusami submitted that there is the election of favor in against the petitioner, and hence CD will reveal the actual fact of it and insisted to cooperate. Next, hearing the submission made by learning process during all aspects. Considering the fact that the petitioner is but for last 26 days, and thus the I got sufficient opportunity to interrogate him, keeping him in custody. So considering the nature of petition, this court is of opinion. This court is of opinion that further custodial interrogation may not be necessary for the purpose of investigation. In view of this, present petitioner is entitled to whose satisfaction this one is?
CGM Kamrup Metro.
Satisfaction.
I'm grateful, man. I'm so grateful.
Yes.
May I please your leadership?
Yes. Yes.
May I please your leadership? The leadership last time asked for the either any case has been registered against this present petitioner or not.
Watch it. Yes, yes. What is the report? You have not received any report?
How? Because your police station.
From Borpeta.
Yes, sir.
Part Mr. Adam Internet. Part Mr. DP Goswami Internet. But states and it is submitted that no report is received by concerned police station. In view of this, letter reminder by issued with a direction to the officer in charge. Which police station this one is?
My lord,
Police
Kalgasia
station.
police station.
Huh?
Kalgasia, my lord.
Kolkata. The OC of the Kolkata police station to furnish the report on or before the next date of listing as to whether any case has been registered against it. Interim be continued till next date of listing. List accordingly. Yes, so when it 18th of this. Okay, 18th of this.
Yes, to report.
Under section 483 of for cancellation of bail.
Oh, this is filed by state. Cancellation of bail. You have annexed the bail order here. Bail order is annexed here. In which bail? You have not annexed, if you have not annexed it, it should be annexed, otherwise. Because as per your index also.
Yes.
Impin order, okay, just a second, impin order 27. Maybe.
28. Making the 28.
28.
28. Next six. Paragraph 13 is the relevant portion.
Acha. On 30,000 surety was allowed, na?
Yes, yes,
That is under challenge.
yes. Only notice at this stage.
Mr. P. Sharma did an additional PPA bringing state respondent of state petition. This is an application for cancellation of bail. Cancellation of bail under section 483, subsection 3 BNSS. Challenging the order of bail granted to the respondent by impugn order dated 13/04/2026 passed by Learned CGM Pro in connection with dispute PS case number 204/6 under section 316 section 2, 318 subsection 4, 61 subsection 2. let the notice be issued through speed post and usual process to the respondent, sole respondent accused. Full stop. You need anything, if bail order is already there, we are issuing notice. Do you need any scan copy, anything?
This stage not required, Lordship.
Not required. Issue notice. Let the matter be listed after 2 weeks or oblique immediately on receipt of the no, like 2 weeks as an edit. You take steps.
Lord.
That I'm appearing on behalf of Mr. A. Rahman. He has some
A.
personal
Rahman.
difficulty.
Lordship, CD has not been received.
CD not received.
CD not received, Lordship. Oh, I'm
It's
sorry,
the case
Lordship.
of 103.
I'm sorry, Lordship. Charge sheet has been submitted. Already charge sheet submitted, Lordship.
So charge sheet has already been submitted. Do you want to have pass any order?
I have limited instruction that
Limited instruction. Okay, then let the matter be listed day after tomorrow.
Lord.
Get here. And the request made by learning counsel for the petition is the matter. Okay, we are listing it on 13 so that your senior can come.
blessings.
26. May I please, Your Lordship? Well, this is an unfortunate case, Lordship. A young boy of 21 years is behind the bar for, Lordship, 117 days. In fact, Lordship, the case is registered under section 87. Your Lordship will kindly see the FIR, that is page 8.
Here we have received.
Lordship, that is already case record.
Yes, Lordship, the scan copy. I
So
have
scan copy is there.
I have flag marked the statement of the victim. It is enough for you.
Yes.
Yes, yes, what you are submitting?
My Lord, the case
Initially,
is
it was registered under 87.
87. He is still under 87 because charge sheet is yet to be served. For framing,
Charge sheet is yet to be.
yet to be framed.
Charges has not yet been
Oh,
framed.
charges is not yet.
Yes. My Lord, CS file under section 87. Based on the Lordship 183 statement, that is corresponding to 164 statement, if the Lordship kindly peruse the 164 statement that it is not a case of POCSO. Victim statement, Lordship kindly peruse the
We
statement.
pay, otherwise, what is your submission? If your
My lord-
submission that initially 87 was there,
So 87,
Ah.
I am behind the bar for Lordship 117 days. Lordship, if I should release on bail, Lordship, because
now you are in behind the bar since 117 days.
117.
And the case was initially registered on 87 and charge sheet was on also 87.
87.
CS
And
was also in 87 then.
And the next date, Lordship, date was fixed on 4/5/2026 was fixed for framing charges. But on that day, no charge was framed, and next date is fixed on 18/5, Lordship. But since the case is still under section, Lordship, 87, because charge is CS is filed based on the Lordship 164 statement. If you Lordship kindly peruse the 160.
Where you are saying, Mr. Sharma, that subsequently the court, there was an opinion of the court.
No. This statement of the victim under 183.
No. Why after special POCSO it is there?
Yes. POCSO was added subsequently, Lordship.
Oh, added
Not yet added.
Oh, not yet added.
Not yet added. That is my case, Lordship. If your Lordship kindly peruse the page, Lordship.
It's one added, I think. But there's an observation, I think.
Yes, observe page 35. Yes.
30?
35.
Page 35.
Page.
Said that since 164 statement, 61 statement.
Second paragraph.
Second paragraph. Only presumption.
Within charges has not yet been framed. It was fixed on 4th of May for charges framing. I'm not sure what.
No, I have the order,
He
Lordship.
said on court it was not framed.
Yes, I
Fixed
have
on
the
18.5.
18.5. This is the online. I have the online copy, Lordship.
Otherwise, Lordship will kindly use this statement for a moment, Lordship, because
Okay.
I have flag mark. Otherwise, Lordship, she is a minor. It is apparent, Lordship. Her birth certificate is in the report.
Years.
Nobody, no. You have taken 164 or 183 statement.
Yes.
Is there.
Yes.
And then in other page,
That is the 161.
that is the 161 earlier or 180.
Yes. There, Lordship.
There are
Yes.
differences.
Yes. And based
It
on
was recorded. It seems that both these statements are recorded on 16.1. Both these statements before police 161 and before
this
sorry 183 or 180 and 180.
Yes.
Yeah,
that,
so
Lordship,
it's a difference. Yes, you want to what do you want to submit?
That only the Lordship, the victim is a minor. So she is allowed, there is no doubt that she is allowed on her own. And she has stated also that she is no physical with the, but she is a minor.
No, 87 is there. 87 was already there. Now the question is this whether POCSO is there or not, but charge is not yet framed.
Yes, that is the.
Though it was an observation by the trial court that he should be before the district just so that it can be now most probably where it is pending cases. Special.
Special just Lakhimpur. Initially,
So
it was
a special just Lakhimpur. That is the only issue. Not yet filed, I think.
has filed.
Been filed.
No, charge sheet file after that, Lordship, that date is fixed for a framing of charges. Charge sheet file under section 87.
Under 87 only.
87. I have
He's
an
saying it 87 only.
Yes, sir.
Regarding this, the petitioner has pleaded also in bail application.
No. Charge sheet is filed on 87 only.
Yes, only 87.
That's what I'm
Only
saying.
court
Charges.
in the observation after perusal of the 164 and 161.
Not only 161. Perusal of 161.
Yes, perusal of
But in fact, 164 is in favor of the accused. That has not been stated in the order. Just 35.
regarding the age, there is no difference.
No, age we are not on age. Age is okay. Age is she stated to be 17, maybe plus minus whatever, but 17 is there. Yes, what will be the purpose of keeping him again for custody? Is there any? As per you, what you want to submit? Because it's not a case that the girl is under 12 years. She is more than 12, is about to be 18. So what do you want? Yes, anything to submit from your side? May not be required.
Some condition.
Conditions may be imposed on.
So see, Mr. Sharma, even if suppose
Yes,
our
ma'am.
statement is not yet recorded, I can understand. But if you go by the two statements,
Yes.
right? And
That is-
because 160, we give more importance than
Yes.
183, the comparison to one,
Yes.
because it is recorded by the court.
That is why Lordship, I insisted on Lordship going to the statement.
Heard Mr. M. Khan, the learned counsel for the petition. Also heard Mr. P. Sharma, the learned counsel, appearing, and MS P. Chaudhary and Ms. P. MS P. Chaudhary, the learned amicus, for the respondent. This is an application section so and so in connection with students. Scan copy of the DCL along with the CD receipt. Films receipt. Next one. Mr. Khan, the learned petition submitted to Mr. that initially the case is registered under section was registered under section 87 BNS and the charge sheet is also filed under the same section of. Subsequently, there was an observation of the court that it ought to have been executed by the Court of Learned Special Judge, as there are some materials which affects the case of the act of POCSO. Mr. Khan further submitted that though the case has been pending before the Learned Special Judge, but there from the materials in the case record and case diary, we make materials in the case record, it is very much evident that the case does not fall under POCSO Act. However, the petitioner is in custody since last 117 days, and hence further custodial detention for the accused may not be necessary. Petitioner is, however, ready and willing to appear before the learned trial court below, as and when it's fixed. Next para, Mr. Sharma, the learned petitioner, PP submitted in this regard. The charge of the case is not yet framed, and it is yet to be framed, though the case is special at present is trying by the learned special judge box. However, he submitted that there is some contradiction in the statement made by the victim under section 180 and 183 of BNSS. Next paragraph. MS Chaudhary, the learned amicus, appearing respond number 2, submitted that there may be some contradiction in the statement made by the victim, but it is an undisputed that the victim was a minor at the time of incident, and hence there may be hampering or tampering with the evidence of the minor victim. Ms. Chaudhary accordingly raised objection, submitted that it cannot be a big case to grant the privilege of bail to the present petition. Next part. During this submission made by learned, I have also perused a scan copy of the TCF and case diary. Accordingly, considering the statement made by the victim under section 180 and 183 PNSS and other relevant factors, this court is of opinion that custodial detention may not be necessary for the purpose of trial. Accordingly, the case is found to be a fit one to send the privilege of bail to the present petition with some conditions which will be with some strict conditions. So, in view of this case is pending by Lakhimpur.
Special just Lakhimpur at not Lakhimpur.
To this restriction of Lakhimpur, not Lakhimpur, Prohibitions.
lordship. But your lordship will also see the charge sheet. Charge sheet does also retain section 103, and they seek to examine 14 witnesses. In the translated copy, your lordship, on page 18, the first line your lordship will see one of the essential factors here, that the deceased was tested positive for alcohol 0.2615 gram and 0.262 grams. That is a relatively high quantity, your lord. Thereafter, if your lordship has the witness statements as part of the TCR, if your lordship can peruse the witness statement. So, one of the witnesses, your lordship, named as Dulumani Das. So, yes, your lord. So, in her conversation, she has said that the victim had called her and told her that due to such and such argument happening between us, he kicked me and left the house. So therefore, your lordship, a simple inference from here that I'm trying to draw is that somebody who was in senses enough to call another person and tell them that an argument had happened did not receive such a grievous injury that it would ultimately result in murder. Thereafter, she may have died. But it cannot be assigned that that in particular injury directly resulted into her death. And same has been verified by another witness, your lordship, that is Konoklata Das. She gives the same inference that she called her and she told her that such and such argument had happened between us, and as a result of the argument he kicked me, and thereafter she left the house. Later on, under what circumstances she was admitted is yet to be found out. And another factor that is proved by the charge sheet itself is that there was alcohol found in her body, and it is admitted that the husband had left the house. So he was not there. So applying the test of Virsa Singh and reading 103 or erstwhile 300 IPC, it cannot be deemed to be an injury that has resulted in death that was intentional on my part. It cannot be culpable homicide amounting to murder, your lordship. And I have been in detention for past 108, 107 days, your lord. Charge sheet has been submitted, case has started. No witnesses have appeared, 14 witnesses are to be examined. So lordship may allow me to continue my defense, best of my possibility.
Here, lordship, the charges has already been framed on 31/3/26. 103 subsection 1.
31(3).
31(3). Under 103 subsection 1. And lordship, the case is fixed for evidence. Last date was 8/5/26. So it is not clear whether any evidence had taken place from the scan copy. Now, lordship, witnesses are totally numbers 19 PWs, lordship. And if lordship kindly takes up only 2 statements, that is not necessary, but lordship, 2 statements, he has mentioned one is Dulumuni Das and one is Konoklata Das. Their statements I have flag marked, lordship. Now what transpires, lordship, is that the victim lady, lordship, before that, lordship, she telephonically informed these 2 witnesses, lordship, that she was kicked, or in Assamese, Guru Mari Diya, lordship. That was done, lordship. And after that, lordship, she fell suddenly ill. And thereafter, lordship, she was admitted in the hospital. Thereafter, lordship, she died. And the medical report also I have flag marked, lordship. It states, lordship, that death is due to hemorrhage and shock as a result of injuries sustained in pelvic organs. That is uterus and fallopian tubes. That is in the PM also, lordship. That is apparent. Now, lordship, the interesting thing is, lordship, when the family members were informed, they were informed that she is suffering from low pressure, and not, this fact was not disclosed to them, lordship. So apparently, lordship, this was clearly planned. Thereafter, lordship, the case, now, lordship, the husband It is apparent, Lordship, these two witnesses have implicated the husband because the victim herself has stated that she was kicked by the husband himself. So that part, these two statements I have only flag mark. Now the only thing is, Lordship, for the fact of trial, Lordship, evidence has not yet started. So in my humble submission, Lordship, I am not going into the merits of the case or the acquittal or the discharge of the petitioner, Lordship. These two witnesses are most vital witnesses, Lordship, and these two needs to be examined, Lordship.
Where is the report, medical or the PM report?
I have flag marked, Lordship.
Same has been reproduced in the chart sheet as well, Lordship.
Yes, in the chart sheet also, Lordship, will find it is there.
Page 17 can, your Lordship can read the transcript report. Lordship, I couldn't agree more with the learned counsel that those two witnesses are very important. Because if Lordship had read the statements, then your Lordship will understand that it helps me as much as it helps the case. Because they have established that after the said incident of the petitioner kicking the deceased victim, she was alive and well and she had communicated this fact to two other persons. Thereafter, she was admitted at 11 p.m. There is no implication as to who admitted her, in what condition she was admitted, from where she was admitted, and what was her condition. None of those things are there. And another aspect that was not explained is that alcohol level. That is also not explained. So in light of all these things, I'm pressing your Lordship. Not that he's making any false statements. He's right that those two witnesses are important, but they are important for me as well, your Lordship. They are proving my story as well.
Now, see, the question is that obviously the alcohol was found, that is admitted. If you go by the medical report, it is exclusively cases of antemortem injuries which sustained by a pelvic region.
Yes.
At the time when she called for it, I was just supposing, wherever maybe the actual fact may not be there. But when she make a call with this lady, one Kanaklata and one Dulumani, at that time, undoubtedly she was alive, no
Yes.
doubt about it. She was alive. But the injuries is sustained, or the remarks he made that he kicked her. What part? That part is not there. But the part is in her pelvic region where the internal hemorrhage and bleeding was started.
Just to
So
add to
that
it,
may be the one of the causes.
Yes, just to add to it, Lordship, sorry, Lordship, just to add to it, the internal hemorrhage or bleeding, Lordship, it takes time, Lordship.
Yeah, it takes time.
That's yes.
That's what I'm
Yes.
just saying. That
We are not
internal
okay.
hemorrhage was there.
Yes, yes.
So bleeding takes time. So at that time, while
Yes.
he was under the telephonic conversation with two lady or two witnesses, obviously that time
So Lordship,
she
now, yes.
felt that one kick was there in her pelvic region. But
No.
that was maybe I don't know.
Yes, your Lordship.
This is
That's
a-
why, again, there is an unexplained set of circumstances in the middle, Lordship, that has to be determined in order to go about the exact story, your Lordship.
That is the exact purpose of the trial, Lordship.
Yes,
My
exactly.
respect. Now, in this bail application, Lordship, we will confine ourselves to the fact. For the purpose of trial, Lordship, these two witnesses are the most vital. So, Lordship, until they are examined, Lordship, there is every chance that they may be tempered or they may be influenced, Lordship. That is also the observation of the trial court. When the discharge petition was filed by them, Lordship, the trial court recorded every submission and after going to merit, refused to discharge the accused. So at this stage, Lordship, for the purpose of bail, until they are examined, the bail may not be considered. Or if Lordship wishes, Lordship can give a direction to the trial court also that these two witnesses may be examined as soon as possible. that will be easier for them also, Lordship. My respectful submission, Lordship.
Such examination may or may not be possible, Your Lordship, in such, I appreciate the learned counsel submission that it may be expedited for our favor. But then again, it's not possible because they might be summoned, they might not come. So therefore, the court cannot wait for two particular witnesses and stop the rest of the trial. That will again will not be in the interest of justice, Your Lordship.
Okay.
So, otherwise, Your Lordship may.
Mr. A. Mishra, the learned counsel appearing, you are appearing before Mr. S. Das?
S.
Or
Navas.
S. Nav. S. Navas, the learned counsel. Also heard Mr. P. Sharma, the learned additional PP appearing on behalf of Children's Parliament. This is an application, also in connection with scan copy of the picture has already been received. Very received. Next, it is submitted by Mr. Mishra that the case was registered and charged under section 103 BNSS. BNSS, but without detailed inquiry made by the investigating officer. If further submitted that at the time of examination, it was seen that the victim tested positive for alcohol with 0.2615, which is a high dose of alcohol at the time of her examination. More so, he submitted that there is no exact cause of death, and the only allegation is that the petitioner kicked her, and at that time she had a telephonic conversation with two witnesses, namely one Dulumoni Das and one Koloklota Das. Koloklota Das. Thus, at the time of her telephonic conversation with these two witnesses, she was alive, and hence it cannot be stated that the cause of death of the present petitioner is only due to injury sustained by her injury sustained by her, where the petitioner is alleged to give a kick to her. He further stated that the petitioner is in custody since last 107 days, and the charges has already been framed, and hence, 107 days, charge sheet has already been furnished, and the charge has already been framed against the present petition, and hence further custodial detention of the present petitioner may not be necessary for the purpose of trial, and that apart is not yet confirmed as to whether the cause of her death was whether due to alleged assault made by the present petitioner. However, the petitioner, being a permanent resident of his address locality, is ready and willing to appear before the learned trial court below on each and every date to be fixed by the court. Next para, Mr. Sharma, the learned petitioner submitted in this regard. That admittedly case is charged, that charge is also framed in the section 103, subsection 1 of BNSS. If further submitted that there are as many as 19 numbers of witnesses cited by the prosecution, but two of the witnesses, namely one Ulumani Das and Kolokata Das, are the two vital witnesses whose evidence is necessary for the trial. And he further submitted these two other witnesses before whom the victim narrated the incident of about the quarrel and also alleged that the petitioner had kicked her. He further submitted that from the PM report also it reveals that death was caused due to as a result of hemorrhage and shock and the injuries sustained by the victim in her pelvic region, including the uterus and fallopian tubes. He further submitted that at the time of her telephonic conversation with those two witnesses, the victim was admittedly alive, but thereafter, due to internal hemorrhage, she died, which also reveals from the PM. Mr. Sharma's word is submitted without going detail into the merit of the case. He submitted that till the recording of evidence of these two witnesses, his bail prayer may not be considered, as they are considered to be the most vital witnesses for the prosecution. Most vital witnesses for the prosecution, and there is probability and probability of hampering or tampering with the evidence of these two witnesses also cannot be denied at this stage. Next, para considering the submission made by Rani Council for the process, I have also raised scan copy of the TCF, the statement made by the witnesses as well as the PM. Considering the submission made by Rani Council for both sides as well as the materials in the case record, this court is of opinion that the above referred two witnesses are the most vital witnesses of the prosecution, and the probability of tampering with the evidence of those two witnesses also cannot be denied. And in view of this court is of opinion that till the recording of evidence of these two witnesses, they bail may not be considered. No. It's fair to consider an equivalent to Milan. However, it is seen that there are 19 numbers of section witnesses, and hence the learned trial court, learned session judge is hereby directed to record the evidence of the vital witnesses, that is the present, the above referred two witnesses, including the medical officer, within a reasonable period, maybe within a reasonable period of 1 month or 2 months from the date of birth. With the above observation, the present stand dismissed, and with the dismiss with the above observation. So your petition is dismissed at this stage with a direction to the learned trial court to expedite the witnesses, especially those two witnesses, to be examined initially.
Obliged, Your Lordship.
May I please, Your Lordship. Versus 483 application, my lord. On last occasion, CD was called for, my lord, along with the medical report, my lord.
Well, it's CD receipt, my lord. My lord. Medical report is also there, my lord.
Today is the 57 days, my lord.
Cases of which nature?
57 days.
Under which
Arrest
case?
15-3.
Huh?
15-3-25. Oh, 15-3-25.
109 was there.
Yes. The medical report is there, my lord. May kindly produce my.
Your petitioner is in custody, sir.
57 days, ma'am.
57.
Yeah.
Your Mr.
Already 57 days behind our, my lord. Further custodial interrogation may not be required, my lord. He will cooperate, my lord.
You are Mr.
A Gayan, my lord.
Heard Mr. A. Gayan, the learned counsel for the petition. Also heard Mr. A. Bush, the learned additional PPA, appearing on behalf of small. And this is an application under section so and so in connection with this. And city received, query received. Next, submitted by Mr. Dan that the present English petitions are innocent. How many petitioners are there?
Well, three, my lord.
Petitioners are innocent and they will not committed any such offense as well as in the If further submitted that the accused petitioners in custody since last 57 days, and hence considering his length of detention, the prayer may be considered. Their length of detention prayer is. Next para, Mr. Bush, the Lana PP submitted that there are sufficient incriminating materials against the present petitions. However, he submitted that the medical report shows that the victim sustained minor injuries in their person. Next part, considering the submission made by Dani Hospital, and have also paid the case diary and the considering the materials available in the case diary, the medical reports, medical reports, which establish the length of detention already undergone by the accused petitioner. This court is of opinion that further custodial interrogation may not be necessary for the purpose of
Sir, only one prayer, my lord. That, my lord, they will not threaten, my lord, both, my lord, prosecutors, informant and the victim, my lord.
Okay.
They will not, my lord, threaten, my lord.
This will be there.
That conditions.
Okay, I've granted.
Deeply
Whose
obliged, my lord.
satisfaction?
My lord, additional sessions just come up.
No, no.
What?
Additional is not.
Pardon? Pardon?
Why additional? CGM.
CGM Kamrup, CGM Amingao.
CGM Amingao. Kamrup Rural. Kamrup Amingao.
Much obliged, my lord. Deeply obliged.
What is the position of 29 Busha?
My lord, 29, my lord, CD not received, my lord. But, my lord, charge sheet has already filed in this matter, my lord. We get a, my lord, intimation from the house.
Intimation is there.
Yes, my.
But they are not present. What to do?
Well, then maybe time being because petitioner's side may is not good.
Can it be on
Or,
time
my lord,
being
date may be fixed, my lord.
বৃহস্পতিবার মানে কি? বৃহস্পতিবার কি তারিখ? 14. We'll at least stay on 14.
My.
None appears on 14. The matter on 14. 5. Interim be continued. Yes, what is the position of 30?
30, my lord, CD not received, my lord.
CD not received.
In this case, lordship pending since November 2025, lord.
Oh.
Bail application, lord. Very unfortunate, lord.
Why it is pending since November 2025?
My lord, on my lord,
Your
23,
interim
my
was
lord,
granted
it
on
was received, my lord.
11/2025 itself. And since then it is pending.
Yes, sir.
My lord, on 23, 2026, my lord. My lord, though, my lord, we have received the CD that was not updated. So, my lord, my lord, it was sent for updation on 23, 2026, my lord.
On 23, 2026, Honorable Court directed to submit up-to-date case diary, but again list on 21, 4, 2026. On that day also not submit this to-date charge sheet, lord. Lordship, it is very negligence manner by the investigation officer pending since November 2026, lordship. This is the call for records from the Honorable High Court, lordship. Investigation officer being a concerned authority, lordship, not submitted and taking this matter in casual manner. It is very unfortunate, lordship. If called for up-to-date case diary, then his personal offense may can be fixed. That is necessary, lordship.
And because detail order was passed on 23.
My lord, my lord.
As well as the speedy trial is right of an accused.
Obviously.
That is negligence manner.
We pray for a short accommodation, my lord. In the meantime, interim maybe, my lord, Interim is there, my lord. It may be, my lord,
Even
extended,
if
my lord.
interim is there, but case is
Yes,
pending.
ma'am,
since
that's true, my
November
lord. That's true, my lord.
2025.
From
There are
11/25, my
petitions
lord.
Quite
this
a
pending.
long period.
Very unfortunate event.
Very short date, my lord. We pray for a very short
Honorable Court
accommodation, my
order
lord.
dated 23, 2026, Lordship. All details
Yeah,
have been
details
mentioned.
order was passed on that day. Every detail was passed. I heard Mr. M. Saikya, the learned counsel for the petition also heard Mr. K. Vishan, the learned additional EP appearing on behalf of state respondent. Post of this submitted by Mr. Busher that CD is, updated CD is not received from the investigative officer. Next, Mr. Saikya, the learned counsel for the petitioner raised objection and submitted that the case is pending since November 2025. And till date, the IO could not furnish the updated case diary. Though the accused petitioner is, though the case has been, not again, no, till date, so and so, which is very unfortunate. And hence strict direction may be given to the IO to furnish the same. Next para, considering the submission made by learned counsel for both sides. The detailed order passed on 20/03/2026 and other aspects of the case. The IO is hereby directed to furnish the updated case diary positively on or before the next date of listing. In default, you will be served with a personal show cause notice. Yes, push up when it can.
My lord, 15 May.
15 to
15.
But they have taken back this case diary already from you.
My lord, from our end, my lord, the communication signal was, my lord, sent, my lord.
No, communication. I'm not on communication. They have returned back the case. They have took back the case diary.
Yes, my lord, for updation, my lord.
Acha, they have already.
Yes, ma'am.
Acha.
On
Yes,
15
when it can be done.
My lord, on 15, my lord. We will send it, my lord, because it's, my lord, and
It may not be on 15th, I think, because it may not reach.
my lord, my lord.
Takes
Then,
some
my lord,
more
next
time
week,
at least.
any date, you, as your lordship.
19, take it on
19,
19.
19.
95, sorry.
Lordship, day after 19, Lordship, probably I will be out of station at Delhi, Lordship.
On 19th?
Yes.
22nd of
Your Lord.
20.
Let's interim be continued.
Deep term.
31 is also, my lord, arising out of the same
31.
affair, my lord. So same order for both 30 and 31.
30 and
31.
30 and
Same.
Take the order go by space. Okay, we are both listing both the matters on 22. Bye.
Same.
32.
33,
But
what is the position? Just a second. What is the position of 33?
33.
33, no, sorry.
My lord, in this case, lordship is dealing this case for third time and overall fourth time, my lord, and all total 6 times, my lord, case diary was called for but not received, my lord.
My lord, in
So,
this,
as
matter,
per
my lord,
interim order, my lord, I went to the IO and statement was recorded, my lord. So my humble prayer, my lord, interim, my lord,
Yes.
that order may be,
Question here?
may be.
my lord, we get a signal, my lord, as per that, my lord, Sarset submitted, my lord, in this matter.
Charge is submitted.
My lord.
Yes, Mr. Roman, charge is submitted.
Yes, my lord, I was on interim, my lord, so. My statement was recorded, my statement was recorded, my statement was also recorded, my lord.
Just a second. Yes, here the charge sheet is seems to be filed on dated 23/01. Your interim was granted on
9/1/26, my lord.
9/1.
9/1.
So as per your instruction, you have already appeared.
Yes, I appeared and statement
No,
reported.
no, why I'm asking, if you have appeared because charge sheet is filed on 23rd of January. So if you have already this on 9/1, that means within 1 week, if I appear, then your statement may be there.
Yes, my lord.
So in that case, we are extending your interim. We'll do
My
for
lord.
15 days by extra.
My lord.
I heard Mr. M. Rahman, the learned counsel for the petition. So I heard Mr. K. Bush and so. Case was fixed for case diary, but it is submitted by Mr. Bush that charge sheet has already been filed. In the present case, under CS number 18 of 2026 dated 23/01/2026. Next, Mr. Rahman submitted in this regard that after obtaining the order of interim pre-arrest bail, the petitioners have already appeared before the IO And just considering the submission made by learning counsel for both sides, the interim granted to the present petition be extended up to 15 days by the instructions. And this may be the part of the W2 message may be the part. Okay, we're extending your interim up to 15 days. You can
Okay.
appeal.
That communication may be taken as a part of the record.
Yes, I have already.
Obliged, madam.
May it please your lordship, Mr. Nawaz is on his legs in another court. May this matter be heard after some time?
What is the position? We have received the case diary.
Yes, madam. CD receipt. 30.
Time.
36.
Yes, what is the position of 36?
36 also, madam. CD receipt, madam.
It is.
Yes, madam.
Lordship, kindly pass over the item for time being. The senior is on legs.
Timing 36. 37.
Yes, what is 37? Justice. We have received the case diary here.
Madam, CD not received, madam. 37.
Not received.
It is charge sheet,
No, it is charge sheeted, madam, and we have received that communications, madam. On
Charge sheet.
30, yes, madam. On 33, 2026, madam. Charge sheet.
Charge sheet is submitted on
Yes,
30
madam.
03 2026.
Madam, 33, 2026.
Yes, 3003.
Yes, madam.
Yes. And the charge sheet number is?
Madam, that is charge sheet number is 32/2026, madam. A communications, madam, we received, madam, from that. That may be also, madam, taken as a part of that.
It will be part of the record protocol. So we are extending your interim up to 15 days so that you can appear with a regular bail application. Otherwise, you are not may not be shown as an conduct. You have already appeared, na? As per your instruction, you have already. Okay. Then we are extending, and this will be the first part of the record. 15 days we are clipping on.
48.
Before the concern court, madam.
Before the concern.
In this case, my lord, so far merit of the case, I am absolutely an innocent man,
What is there?
My lord, here also, my lord, charge sheet submitted, madam. We have received one communication.
Yes,
lord-
anything you want to submit, Mr. Todd?
Yes, my humble submission is that, my lord, two persons were made an accused, madam. I am the secretary and the imam.
So
In
you
fact,
don't
madam,
know against whom the charge sheet is filed.
charge sheet is fine. My humble submission is that, my lord. In this case, my lord, the informant lodged this FIR just to cover up his corruption.
It's okay, we are not on
So, my
merit
lord,
now.
the co-accused is an absolute bail, my lord. And I am
We
an
are
interim.
on merit because before us, neither we can say anything nor Mr. Bosho in a position.
My-
So charge sheet is not there, you want to submit. This FAO stands dismissed. And the order passed by the Learned Civil Justice Senior Division Kamrup M. Gauhati in Miss Case number 852 of 2025 dated 6/11/2025 is hereby up. FAO stands dismissed.
Fine.
And this IA Civil is also there. In IA Civil, the petition is allowed with a direction to both the parties to maintain status quo over the suit property. And if there is any violation of the order dated sub 26/11/2025 is concerned, parties are directed to remove all the movables as well as the immovable installed after the status quo order has been passed on 26/11/2025 status quo over the 26/11. Does this criminal petition stand dismissed and disposed of?
Deeply approved. Please go ahead.
Carry order 47.
Here is with your lordship. On last occasion, lordship had called for the TC and medical report as well.
Medical report was also called for.
It has been received, lordship. In the frontal region, laceration has been found, lordship. It has been stated as simple. In one of the accused, one of the victim, lordship, his name is Abul Khalek Mondol. And in respect of lordship, one more injured person, that is Sopaluya Mondol.
Sofaullah
Mondol. He has suffered fracture, lordship, in the ankle, previous injury.
Any description about the object?
Unknown, lordship. Unknown. It has not been stated. The weapon has not been stated, lordship. So these two are the victims, lordship, injured person, and lordship, regarding their involvement, they have been implicated by the injured persons, lordship, by name.
They were named in the FIR as well, lordship.
That is the,
Otherwise, they have been implicated.
yes.
Otherwise, our plea remains the same, your lordship. It was a case of marpeat. We suffered injuries, they also suffered injuries, your lordship. The informant that, as the learned prosecution pointed out, Abdul Khalek Mondal, that is the informant. So he has received only simple injuries and in allegedly protecting the main victim, that is Sofaullah Mondal.
And
So we are ready to cooperate, your lordship.
one last submission, lordship. This present petitioner, Sohar Ali, lordship. He has a background, lordship. He was charge sheeted in a case in Kazigaon PS case 33/25, which was under 87 BNS, lordship.
Kajigaon PS?
33/2025. That has already been charge sheeted, lordship. It was under section 87 BNS.
Otherwise, only victims or the injured have implicated all three petitions.
Yes, yes.
And any other submission from your side?
That's it, lordship.
As per you, there was a mutual market.
Yes, your lordship. Some dispute was between the parties. They engaged in the market and as a result.
Or is it any land dispute or what?
There is land and business, basically, lordship. Some regarding how are they operating their businesses and everything. So regarding that, then the affair was lodged by the informant, including this. We are not disputing that there was a market, but we are ready to cooperate with the police if the lordship allows.
Or Mr. A. Mishra, Related Counsel for the petition. Support Mr. B. Sharma, Related Additional PP, applying to the POCSO. So in connection with Sweat, city received. Next, submitted by Mr. Mishra that the petitioner committed. However, it is the fact that on mutual conflict takes between two groups due to some business relations wherein both the parties sustain some minor injury. That apart, both other incidents that taken place as allegedly. However, all the petitioners are ready and willing to extend their cooperation in the further investigation of this case if they are provided with the privilege of pre-arrest bail. Next, Mr. Sharma, the learned additional PP submitted in this record. All the victim of the injured had implicated the present petitioner, showing their involvement in the arrest. It further submitted that one of the victims sustained some minor injuries, but one other victim sustained some fracture injuries on his ankle, which is a grievous in nature. Further, he submitted that the accused petitioner number 1, Sahir Ali, has earlier criminal antecedent, and he is also as an accused. He is an accused of a case registered under Kajigaon PS case number 33 of 2025, which has already been charge sheeted under section 87 of the PNS. Mr. Sharma accordingly submitted that custody interrogation may be or
one last example. He was admitted on 20 Lordship, 20 January Lordship, and he was discharged on 26th January.
26.
Admitted on 20 January 26th and discharged on 26th January Lordship.
So there was a period.
Yes.
To term a case as a
yes, grievous.
Earlier 326 or 1 month
Yes.
present.
For grief,
But whether this period 6 days covers that period?
no, your lordship, 15 days
Yes,
now.
15
Earlier
days.
it was 20 days.
Yes.
Now it is 15 days.
Now it is 15 days.
So that period is most probably
Yes.
6 days. So maybe further Mr. Sharma submitted that submitted that the victim of the injured Sakulla,
Soafulla. SOA
FAU
LLAH.
Wow.
Something like that.
Which is Sapayulla ne kiba Sakulla.
Sofaullah.
Paulla.
Sofa, SOFA, Sofa Ullah.
Acha, he sustained. No, he was admitted in the hospital for his injury on 20/01/2026 and discharged on 26/01/2026. Hearing this submission made by an process, I have also verified the case died, and it is a fact that some of the witnesses as well as the injured implicated the present petitions implicated the present petitioners and alleged that they have committed, they have assaulted the victims. However, considering the nature of injuries sustained by the victim and other relevant materials available in the case diary, this court is of opinion that custodial interrogation may not be necessary for the interest of the investigation. In view of this, all the 3 petitioners are hereby granted the privilege of pre-arrest bail. Okay, you are granted with privilege of pre-arrest.
Obliged, Lord.
I think I have under number 34.
Wait, please, your lordship. Using anticipatory bail application, my lord, the petitioners were granted interim bail, my lord, 34. Thereafter, they have appeared and statements were recorded. In fact, when they appeared, they got arrested in another case because what had happened initially, we lost a case against the informant side. Your lordship will see, kindly see.
Can it be after a few minutes, lordship? Just a few minutes, lordship.
CD receipt.
CD is resolution.
Okay.
My lord.
Yes, what about 36?
36 CD received, lordship.
On the last occasion, lordship, CD was interim was granted and CD was called.
Not received.
Received, lordship.
No, today received.
Today received, yes, lord.
You are saying on last occasion?
Oh, lord. In the. Kindly see the order dated 9/2/26.
By that you are granted with
Interim bill.
page of the-
Wherein my statement was, lordship, my submission was nicely recorded, lordship, that may be paid.
So basically your case is that false case is lost due to as a counterblast. Because of case pending against the son of the informant.
Two petitioners before your lordship, they are father-in-law and son-in-law in relation.
What was the offense? It was an attempt of commit.
Attempt.
Attempt to commit rape, that apart. What case is registered under? 31474.
74, 76, 79.
These are what? 74 is?
Criminal force, assault or criminal force.
Earlier reading.
Yes.
Is Robbie. Yes, sir.
Yes, Lordship has gone to the FIR, Lordship. The allegation that she put, Lordship, is against these two persons, and it is of 21/12/2025. Only, and after the incident, Lordship, she lost her consciousness. Thereafter, Lordship, her neighbors heard it and they took her to the hospital. And Lordship, the medical examination was done on that day itself, that night itself, Lordship. And in the opinion, Lordship will find in her private parts, Lordship, bruises were found, 2 in number. In the Lordship, I'm just forwarding the medical report.
Lordship, entire incident shown to have been occurred, Lordship, within 30 minutes, Lordship. Within 30 minutes, they attempted, and then her husband come, Lordship.
Down below, Lordship, will find the injury. Down below. And next page also, Lordship. And Lordship will kindly turn the next page. Yes, there, Lordship. All these injuries were found in the woman, Lordship. And she has narrated the incident before the examining doctor also, Lordship. It tallies with what she has stated before the FIR, in the FIR. And these two persons were present there, Lordship. So at this stage, Lordship may kindly reject the application because they are neighbors, Lordship. There is a threat to her life.
Seminal stain was also found on her.
Yes, in the leggings. Yes.
Otherwise, these two petitions, they have appeared.
Yes, one has appeared. Noor Islam has appeared. The other person, that is not updated, Lordship.
For my information, Lordship, both
But
are
the interim was granted on the same day.
Yes.
One appeared.
Yeah.
Lordship, in FIR, Lordship, for a moment, Lordship. In FIR, third line, 21/22/2025 তারিখে রাতে 1:30 বজাত নিম্নলিখিত আসামি গণে আমার সহজত সোমায় আৰু 1 নং আৰু 2 নং আসামি মোৰ ঘৰৰ দরজা ধাক্কা দি মোৰ কোঠাত সোমায় আৰু মোৰ কাপোৰ কানি ছিঙি ধৰ্ষণ কৰাৰ চেষ্টা কৰে। এনেতে মই বাধা দিয়াত মোৰ মুখত সোপা দি মূৰত আঘাত কৰে, ফলত মই অজ্ঞান হৈ পৰি যাওঁ। পিছ ৰাতি 2টামান বজাত Lordship, they allege that Lordship at 1:30 they entered into the house, and 2 p.m. her husband Lordship came back from the religious functions, Lordship. Within 30 minutes have been occurred. In the petitioner, Lordship, with two petitioners, Nurul Islam is the Lordship, the husband of the earlier informant who filed FIR against the son of the informant, Lordship. And petitioner number 2, who is the father of the informant, that informant, Lordship. And case is, Lordship, also pending and political trial is going on, the landed court below. So, Lordship, we have been enjoying interim order more than 3 months, Lordship. Our custodial interaction may not be required, Lordship. If something happens, Lordship, it may be in, Lordship, in the trial. Who entered, who caused inflicted injury, Lordship. Fact is unbelievable, Lordship. Father-in-law and son-in-law, Lordship. Custodial interaction may not be required, Lordship.
But it's a petition. The also had also had Mr. B. Sharma in appearing it is submitted by Mr. Thakur that a false allegation has been brought against him only to arrest him as and the present FIR is the contrast of the FIR lost by the wife of the petitioner number 1 with the allegation that the son of the informant had sexually assaulted their minor daughter, for which the case has already been registered. Further submitted the considering the situation and circumstances mentioned in the FIR also, it is not at all a believable story. Very good. Father and son-in-law, father-in-law and son-in-law cannot come together to commit such kind. He further submitted that custody interrogation may not be necessary in the present case. However, the petitioner have already acted and cooperated in the further submitted, they are still ready and willing to extend their cooperation if they are granted the privilege of re-arrest. Mr. Sharma demanded additional video, raised objection and submitted that there are sufficient preventive materials against the present petitioner, and that it is evident from the medical report that she became unconscious when the neighboring people took her to the hospital for examination, and during examination there were sufficient mark of violence on her private parts, and the stain of cement and the stain of suspected cement is also available on her nightie as well as the legs, which has already been sent for medical examination. However, report is still awaited. Further, is submitted that medical evidence fully supports the case of prosecuting, wherein he alleged the sexual assault on her, and that apart, she was also felt unconscious, wherein the petitioner took the advantage and and by breaking the lock, took 1 lakh rupees, which was kept in her house at that time. Mr. Sharma accordingly submitted that considering his benefit vis-a-vis state medical report, it may not be a fit case to extend the privilege of dearest will to petitions. So, that apart, only the accused petitioner Noor Islam may have appeared before the IO, and his statement is found available in his time. But the other co-accused, his statement is not available, and he has not appeared before the IO till date. Expert hearing the submission made by Randy also proposed, I have also read his diary, and considering the methods in the case diary, statement made by the victim vis-a-vis the medical report, wherein injury mark of violence and injury was found on her private, and also suspected semen was also detected in her on her nightie and leggings, which were sent from the medical sent for medical examination vessel at the FSL post. Considering all these aspects of the case, vessel is also considering the non-cooperation of the accused petitioner number 2. This court is of opinion that it may not be a fit case to extend the privilege of pre-arrest bail to the present petitioners, and accordingly, the order of pre-arrest bail dated 9/2/2026 is hereby stands vacated, and the present anticipatory bail is hereby accepted. Your petition stands rejected, and the earlier order dated 9/2/2026 of interim bail also stands vacated. It's a very nasty allegations has been brought against.
44.
May it please, my lord. It's a 482 application, my lord. FR is page 13, my lord. Case diary was called for, my lord.
40?
44, my lord.
Now, out of the time being assigned, which is 44 is also time. So it is also time being.
Yes, my lord.
Oh.
My lord, FR is page 13, my lord. Here is a land
When you
dispute.
received the case diary here,
Yes, Lordship.
FIR is at page?
Page 13, my lord. Land dispute going on, my lord, between the parties, my lord. May I read, my lord? With due respect, humble gratitude, I beg to state that on 23/02/2026, at about 8:30 in the morning, when my aunt was going towards the paddy field behind our house, accused persons, namely Mizamuddin Ahmed, son of Nitsamuddin Ahmed, Yasminara Begum, Rosemary Begum, resident of Pheloguri, from the same village, assaulted my aunt in the courtyard and confined her inside a locked room of their house. My mother came to know about the incident and informed me. When I went to the accused house to bring my aunt back home, the accused person assaulted my aunt and kept her locked inside a room in an unconscious condition. I entered the house of the accused, and thereafter, without any reason, the accused person caught hold of me, threw me to the ground, and caused injuries to my neck, back, and head. When I shouted, people came out, and my aunt was brought out from the locked room. Thereafter, the accused person fled from the place. Therefore, I humbly request to the conduct an investigation into the matter and take appropriate action by punishing the guilty persons. As per the information received, my elder sister is presently under medical treatment. The accused person assaulted me and my aunt with the intention of causing death or inflicted grievous injuries upon us, my lord. As for FIR, my lord, above, my lord, he stated that in unconscious condition. Then, my lord, middle person, he said that my aunt was brought out from the locked room, my lord. She willingly, my lord. Then, my lord, where from elder sister came in the scene, my lord.
Initial, my lord, in the top of the line, my lord, only aunt, my lord. She is, my lord, in the Mizaddin Ahmed house, my lord. Last, my lord, she says that my elder sister, he says that my elder sister is still under medical treatment, my lord. Now, my lord, that is this FIR 23/02/2026, my lord. Page 16, my kindly, my lord, come to page 16, my lord. That is on 16/02/2026. My mother, my lord, filed an FIR before police, but my lord, police has not investigation the case, my lord. May I read, my lord? Page 16, my lord. With due respect, I beg to state that on 16/02/2026 at about 9 in the morning at my land measuring approximately 12-13 bighas situated at Bheloguri, where tomatoes were cultivated and the area was fenced with bamboo. The accused person mentioned below without any reason jointly cut the fence and damaged about 150 tomatoes plants. At present, the price of tomatoes is quite high, and due to their actions, I have suffered considerable loss. Therefore, I seek proper justice regarding why they cut my fence and caused such damage, my lord. That dispute is going on, my lord. Thereafter, this incident, my lord, happened, my lord. And my lord, medical report was also called for, my lord. They have cut my tomatoes plant, my lord, 150 numbers, my lord.
Yes, Lordship, here there are two victims, Lordship. One is Rahena Begum. She is around 55 years of age. She has suffered, Lordship, 3 injuries. One is, Lordship, swelling and confusion over orbital region near her eye, Lordship, which is very grievous, Lordship, because it's just near the eye, Lordship. And next is, Lordship, scalp region, she suffered injury, and in hand also she has suffered injury. And the second injured person, Lordship, Alom Ahmed, he has also suffered 4 injuries, Lordship. All are simple injuries, but it's by sharp object, Lordship. Now, Lordship, everything, there are many eyewitnesses to the incident, Lordship. Apparently, Lordship will peruse only one statement of the injured woman, Lordship. Apparently, Lordship, there is a history behind them. They have dispute regarding some land, Lordship, regarding the boundary. But Lordship, on that day, the occurrence did take place and the lady was, Lordship, she was mercilessly beaten. It has been stated by the other eyewitness also. This is the statement of the victim, Lordship.
My lord, petitioner's mother's also, my lord, made accused in 16 to 2000, Rehana Begum, my lord. She also involved, my lord, our damaging 150 tomatoes plan, my lord.
So your case is not yet raised.
No, my lord, the police has, because, my lord, they have not give importance that a plan destroyed. If man or other person destroyed, then give importance. It is plan destroyed. Why give importance, my lord, police? Then if that time they have investigated, this type of incident will never happen, my lord. If police give importance our FIR, my lord, investigated and call them, my lord, then this type of incident will never happen, my lord. They have not given importance because tomatoes are destroyed. Tomatoes are not matter, my lord, according to them. All this dispute is going on.
Sharma Dilanit and PPFP. It's an application. Submitted by Mr. Odita, Dilanit Bob. That present experiments are used except some land dispute. Nothing had happened as present here. He further submitted that initially an allegation with that the aunt of the informant sustained some injury along with the informant. Thus, on the later part of the FIR, it has been brought that his elder sister also sustained injury without any mention as to how the elder sister also arrived at that in the place of occurrence. He further submitted that actually the petitioner, the informant side had damaged their tomato cultivation, which caused huge financial loss to the petitioners, and to that regard, they also lodged an FIR to the police station. But considering it to be a less important matter, their FIR was not raised. Mr. Rita, however, submitted that the present petition is ready and willing to extend his cooperation in the investigation of this case if he is granted with some interpretation. Mr. Sharma Dilanet will be submitted to the state. That there are two injury reports available in the case diary. Wherein the two victims sustained injuries on their person. The injuries are described to be the minor injuries. Post he further submitted that this petitioner is implicated by the victim as well as the other witnesses, and this is who assaulted the victim, in the place of occurrence. Mr. Sharma does raise objection submit that it may not be efficacious to extend the privilege of pre-arrest bail to the petitioner at this time. During this submission, so the case diary. Considering the materials available in the case diary, the nature of offense sustained by the injuries, and also considering the fact that there was a land dispute between both the parties. This court is of opinion that custodial interpretation of present petition will be required for this to be this the prayer for the arrest bail for the present petition is there. Okay, we're done.
Ablash.
I think for
Please, Your Lordship. In this case, the petitioners were granted interim protection. Thereafter, they have appeared, my lord. And in fact, my lord, custodial detention part also got taken care of because when we appeared, another case was lost by the informant side. In that case, we got arrested. We spent 36 days in custody. Then this honorable court gave bail, saying that the injuries were simple in nature. I will submit on.
I will send a submitted matter, take history of matter. Even their statement is recorded. On earlier occasion, my lord, there is my lord was pleased to my lord call for two numbers of cities, my lord. One is my lord, the present case is my lord, 766/2025, that's for police station case number. And another one is my lord, 764/2025. But in case of 764/2025, my lord, you get an intimation, my lord, that is the my lord, completed.
In 764.
764/25.
That is the case, my lord, which we lost, my lord. First case, my lord.
You lost.
We lost, my lord. Your lordship will kindly see page 14, my lord. Page 14, your lordship will see there's a cut injury, my lord. Several stitches on my face, on one of our family members' face, my lord. And page 15 is the medical report, my lord. So multiple injuries on our face, my lord. So thereafter, we lost this 764 FIR, which your lordship will find at page 16. In that case, my lord, already investigation is over and charge sheet has been submitted.
Under which police?
Thereafter, this FIR was lost. This honorable court gave us interim protection. We appeared and our statements got recorded.
So in which case again you put
So when what happened was they lost two cases against us. 764 we lost, then they lost 766 and 768. We were not aware of 768. So we came before this honorable court in 766. This honorable court gave us protection. When we went to the police station with the bail order, they arrested us in 768. That was because we were not aware of that case. Subsequently, we were granted bail by this honorable court in that case also.
That was 768.
768.
This is item number 34. Part Mr. S. Nawaj. Also part Mr. E. Bush. The learned additional PC appearing on the update on this is an application. Connection CD receipt based receipt. Next right is submitted by Mr. Nawaz that after obtaining the order of interim arrest pay, the accused. How many petitioners are here?
There are 6 petitioners.
All the petitioners have appeared before the investigating officer to cooperate and to record their statements. When they appeared, and accordingly their statements were recorded, but during that period, all the petitioners got arrested.
4 got arrested. 4 got arrested.
4 petitioners got arrested in connection with another FIR lodged by the informant, which was registered as 768/2025, which were not and the petitioners were not aware about the said FIR. However, after 36 days in custody, the accused persons got bail and got bail. It further submitted that prior to the lodging of the present FIR, the petitioners have already lodged an FIR before the police station, which has been registered as Dispute PS case number 764/2025. Subsequently, the present FIR has been lodged by a petitioner as a customer. However, petitioners are still ready and willing to extend their cooperation in further investigation of this case if they granted with the privilege of appearance. Mr. Busho, the learned additional PP submitted in this report that there are some implications against the petitioners. However, POCSO, all the petitioners have extended their cooperation and their statements were also recorded. He further submitted that the CD of the case lost by the petitioners as registered under dispute PS case number 764 2025 has already been charge sheeted and the report is submitted by the IMA. Yes, something we don't need all this go.
Because
details.
that is not the my lord.
Not my
Only because my lord earlier order was there. Otherwise, their statements recorded, my lord. Though my admittedly sufficient investigating materials are there. They appeared and that is recorded.
Next one, hearing the submission made by London Council for is diary. And the fact that there are some implementing materials brought against the present petitions by the injured the victim and the other witnesses. However, it is seen that they have already appeared and cooperated in the investigation. But it is said that the case lost by the informant that as petitioners have already ended with the charge sheet. So considering all these aspects of the case and the materials available in the case diary, this court is of opinion that custodial interrogation may not be necessary for the purpose of investigation. In view of this court is of opinion, and then in view of this, the pair for interim periods failed hereby allowed, and the order of interim periods failed granted to the petitioners dated 4/02/2026 is hereby made absolute with same terms.
I'm deeply replacement.
Number 16.
Made to your lordship. In this matter, the affidavit of income tax department, the sole respondent is pending. They were to take instruction.
Department is here.
Income tax department, your lordship. May I pray like this, your lordship? The file was there.
Yes, none appears for this income tax department. Mr. Kyle was there.
Yes, he was appearing earlier. Yeah.
Supposed to file an affidavit.
They are supposed to file an affidavit, your lordship, and they are supposed to take instruction. Because what has happened, your lordship, that we have filed our return, income tax return for 2016 and 17. And the scrutiny happened, and we had filed for income of around 8 lakhs. There was an assessment which was done by the department. And an erroneous finding was there that they're holding us as a retail outlet. We are actually bonded warehouse. They hold us as a retail outlet, and our income was considered around 35 lakhs. So we went to the Commissioner of Appeals. So we got partial relief there. Since we got partial relief, we subsequently went to Income Tax Appellate Tribunal in Kolkata. And the matter was remanded back. But in the meantime, the department already filed a criminal complaint against the company as well as the 2 directors.
After this development, you have not approached the department concerned.
Lordship, we have filed an additional affidavit. On the last occasion, they were to take instructions, your lordship. The last.
No. I can understand.
Lord.
After those developments that you have got some relief and you have visited to the office of the Kolkata, these are things that happen. So thereafter, have you approached the department?
We approached the department. There was a penalty of 10,000. That also we paid, your lordship. But your lordship, the criminal case is still pending, your lordship. Now today, your lordship, I'm not pressing it because there are 2 other connected matters, your lordship, which is not listed today. So if I may.
Connected
matters, because there are 2 cases against the director where interim stay has been granted by this honorable court. So unfortunately, this has not come today. So if the matter can
just
come.
tell us the other numbers.
Yes, sir. The others are criminal
These are,
petition,
those are also criminal petitions or?
criminal petition. Yeah. So we are the company and the other two are the directors.
Okay.
Criminal petition number 168/2022
168
oblique 2022 and the other one is 165/2022.
2020
2022, Your Lordship.
2020.
2022, Your 2022,
Achha,
Your Lordship. My apologies. So if can be listed after 2 weeks and Your Lordship, and in the meantime, if the department can respond, Your Lordship. The last 2 years, no affidavit, no instruction.
Today also they are not here. In the morning hours, just you could have informed us, then we could have notified the Mehdi.
Lordship, he was
Notice
here.
could have been given then, but at this stage, though, it may not be possible.
Lordship, let it come after 2 weeks, along with the other methods, Your Lordship.
You are Mr.
V. Rajkoya.
V. Rajpur. Mr. V. Rajpur, the Lanit 16, and counsel for the petitioner. Then appears call for the respondent of the income tax department. It is expired, is submitted by Mr. Rajpur that the department, the standing counsel of the department, submitted that the respondent of the department was supposed to take instructions and to file an affidavit in regards to the subsequent development, if any. But they remain absent. Though on the last occasion, they took 2 weeks' time to obtain instructions from the department. In view of this, the respondent income tax department is hereby asked to take necessary instructions within 2 weeks from 2 weeks and to submit the same in the form of additional affidavit, if any, so that matter can be heard and decided. Further, considering the submission made by Mr. Raskwa, the present criminal petition be listed along with criminal petition number 168 of 2022 and criminal petition number 165 of 2022 on the next list. The registry will do the list after 2 weeks.
Can it be on 29th, Your Lordship, 28 or 29th?
He is saying that it will be based will be on the 3rd of June. And it,
Lordship. Oblige. Your.
Meet please, my lords.
it's 20 both the parties are ready.
My lord,
Okay.
Well, in this case, notice was issued by my lord. And thereafter they have received of the notice, they have appeared. The matter was once heard by my lord Justice Chaudhary, Manish Chaudhary, my lord. And thereafter the matter has been, my lord, fixed on 5/3, but for certain reasons it could not be taken. Thereafter on 7/4 it could not be taken, my lord. Because of my demise of my younger brother, I could not take.
It's your petition, you start.
I've no difficulty.
So now it's ready for admission because they have already appeared.
My lord? Yes, my
They
lord.
have already appeared.
Yes, my lord. They have appeared. They have appeared here.
Okay.
Well, here the questions basically,
Yes.
two questions arising for consideration of this, my lord. One is that section 173(8)
Yes, 173(8).
of CRPC, my lord. One of the question of further investigation.
Before that, my lord, I'll take to my lord to the factual aspect of the matter.
Yes.
My lord, in 17/5/2022, my lord, this Matak Autonomous Council appointed Partha Bhardwaj, one of the accused, my lord, not me, my lord, for facilitating procurement of central government scheme, particularly from Social Welfare Department. The appointment letter is countersigned by Saroj Gauhati, Chairman, and Devika Chetia, Deputy Chairman, and David Chetia, Chief Executive Council. So he was the person, he said that he was appointed as an advisor. Now,
What was his name? Name?
you know,
Name was? Name.
the Partha Bhardwaj.
Part.
Partha Bhardwaj. As an advisor.
Hmm.
And this letter was issued by the chairman, deputy chairman, and all of the council, autonomous council. Now, the allegation is that, if your lordship will kindly come to the FIR at page 93, my lord. My lord, got it.
90?
93, my lord.
Yes. Yes, 92.
Now, the complaint has been filed, my lord, for fraudulent activities by Mr. Partha Bhardwaj, Matak Autonomous Council, Dibrugarh, Sudipta, then Partha Bhardwaj, Rasendra Thakur, then Rajesh Bansal, Nagappan Kurappan, V. Srinivasalu. I am my lord V. Srinivasalu. And other known unknown persons inter alia for the commission of serious cognizable offence under section 2. There are various sections of law. Then, if your lordship will kindly come to page 96, the facts of the case. My lord, for the purpose of 173, my lord, I will not place the entire my lord, FIR. Because my lord, I am basically on two questions. One is that 173(8), my lord, there was no order from the magistrate for further investigation. This is first. No fresh material has been, my lord, discovered. Thirdly, my lord, already, my lord, charge has been framed against Partha Bhardwaj in respect of the first charge sheet that has been filed, and my lord, the trial began. In these three contingencies, my lord, the order taking cognizance is against me and others. But I have changed mine one, my lord. Is my lord illegal, and my lord is liable to be quashed. This is first. Second aspect of the matter is, my lord, that even if your lordship takes into consideration the entire materials which has been collected by the investigating authority and placed before in the charge sheet, my lord, no case is made out as against us. So, my lord, so for the second question is concerned, my lord, I'll place the FIR, not right now, my lord. Right now, my lord, I'll be showing to my lord that this FIR was lodged on 8/4/2024. That your lordship will find at page 93 to 108, my lord. Page 80 to 108.
Facts started from 96, page number 96.
My lord,
Facts
now
of the
facts
case.
started from 96, not prior to that. May if need be, may just read that. In December 2022, R.B. Thakur, Rasendra Bhavani Baksin Thakur, that entire name, along with Rajesh Bansal, approached me regarding Assam government projects presents themselves as consultants. At his residence at Jasola, Delhi, Mr. R.B. Thakur, he has not been charge sheeted, my lord. R.B. Thakur introduced me with V. Srinivasalu as an old associate of Mr. Rajesh Bansal, who can get our society work orders from Matak Autonomous Council and other departments of other departments. Mr. R.B. Thakur emphasized its context with Assam government, suggesting that he could facilitate supply contracts for our said society firm, since our society firm, this is Susila Gramodyog Sanstha, is already registered for various government supplies, and Mr. R.B. Thakur and Rajesh Bansal requested us to provide all connected documents required for registration, impellment with Matak Autonomous Council, Dibrugarh, and after obtaining all necessary documents from us on 29/12/2022 for the impellment of our firm with Matak Autonomous Council under Assam government for contracts and supply. He provided us the registration certificate, register our society Susila Gramodyog, a supplier under the contract supply, the registration number allotted to us in so and so. Our registration remains valid till 31/3/2025 in compliance with the Assam Gazette so and so and so. After the aforesaid registration of our said society, Mr. R.B. Thakur and Mr. Rajesh Bansal arranged a meeting for us with concerned authority. The Lordship will kindly see, this is important. R.B. Thakur and Rajesh Bansal arranged a meeting for us with the concerned authority in Matak Autonomous Council, Dibrugarh, for obtaining the supply orders. Therefore, on Itna, 28/1, I went to Dibrugarh and the same day met Rajesh Bansal at the office of Matak Autonomous Council, Dibrugarh, where aforesaid Mr. V. Srinivasalu was present, and I was introduced to Nagappan Karappan. I was told by all of them that me, V. Srinivasalu and Nagappan Karappan are the liaising agent for procurement and felicitation of purchase orders of Matak Autonomous Council, Dibrugarh, Assam. Mr. So-and-so and so-and-so confirmed the aforesaid to me. Mr. Rajesh Bansal, Mr. V. Srinivasalu and Mr. Nagappan told me that they work as a team. Thereafter, Mr. So-and-so scheduled my meeting on 30 with the concerned officers of Mrs. Matak Autonomous Council, Dibrugarh, Assam. The scheduled meeting at the office of Matak Council, Dibrugarh, I was introduced with Mr. Partho Bhardwaj, an officer in charge, and he discussed with me regarding procurement of mass orders, motor pumps, blankets, mosquito nets, school bags, schoolers, Paras attack on so-and-so. Mr. Partho portrayed himself as the government authority. Now, this is important. Partho Bhardwaj portrayed himself as the government authority who has been mandated for mass procurement of these items meant for people of the state of Assam through various states. Schemes implemented by the Matak Council and has been authorized to procure them directly without a tender. He assured us that our farm society fulfills the legal requirement of a supplier, placed purchase orders with us in office of Matak Council, Dibrugarh. Named board of Partho Bhardwaj was placed outside his office as OSD. And therefore, in view of meeting having been held in the office of Matak Council in the room of OSD, I could not suspect that intention of these persons from very beginning was to cheat, commit fraud on our society. During the aforesaid meeting, Mr. Partho Bhardwaj also informed me that Matak Autonomous Council also has an administrative office in Gauhati, and all future administrative work would be felicitated from the Gauhati office. He also informed us that the supply will be held, received in Gauhati branch office so and so. At the end of the aforesaid meeting, Partho Bhardwaj invited me to Gauhati office, Matak Councils on Itna for further action. He also informed me that security deposit of equivalent of 5% of the order amount will be required to be paid in case. When I offered to make bank transfer, he emphasized and insisted that the security amount has to be paid in case only. He assured us upon completion of the supply order, this deposit will be refunded. Mr. Nagappan, Kurappan and V. Srinivasalu and Mr. Rajesh Bansal followed up with me for the meeting fixed by Partho Bhardwaj on Itna in the office of Matak Council in Gauhati, Assam, and they accompanied me for this meeting, where we met Mr. Partho Bhardwaj. This office of Matak Council where we met is located at so and so and so. This place is given. During the meeting, Mr. Partho Bhardwaj informed me the autonomous nature of his council office under so and so, asserting that he is authority to procure goods amounting to up to rupees 2,000 crores annually from eligible suppliers without the necessity of tender route. Further, Mr. Partho Bhardwaj informed that utilizing funds sanctioned by the government in India Assam to Matak councils exceeded rupees 500 crore and he has to use the funds before the sanction lapses. Mr. Partho Bhardwaj told me that as our society was already registered with Autonomous Council, dated so and so, has impaneled Susila Gramodyog Sansthan for materials and Matak Autonomous Council. Mr. Partho Bhardwaj assured me that he will process the order in favor of our society and would be dispatching the orders as early as possible. However, he has again reiterated the requirement of deposit of 5% of the order amount as security deposit to be paid in case to him the order would be executed. Thereafter, Gramodyog Sanstha received 3 works order on via courier on 13/2. Supply signed by the Principal Secretary, Matak Autonomous Council, Dibrugarh, under containing round seal of Government of Assam with national envelope. So, these are the details of the 3 orders. The receipt of the aforesaid orders, Mr. Mrs. Susila Gramodyog Sanstha and R.B. Thakur contacted me again and reiterated the condition that 5% of security deposit before the commencement of the supply order. Therefore, on Itna, I paid Rajesh Bansal and R.B. Thakur rupees 1 crore in case at the tower so and so towards the said security deposit, said supply order. The amount was paid by me in presence of accountant of Mrs. Susila Gramodyog Sansthan, that is Dipesh Joshi. After this, in compliance with the aforesaid work order on 14, the Susila Gramodyog Sansthan concerned supplying goods to Matak Council as evident by the detailed supplier's ledger and relevant documents, invoice so and so, amounting rupees 3 crore and odd. These supplies were made between 14th March 2023 to 31st March 2023. Detail of invoices are, I am not reading this, these are the details of the invoices. Meanwhile, the Partho Bhardwaj, Rasendranath Thakur, Rajesh Bansal, Nagappa Kupan, V. Safi continued to raise demand for remaining security deposit amount from me. However, I requested for more time to arrange cash withdrawals from account than I could only be done after the first week of April 2003. In the first week of April, Nabakka and Srinivasulu informed me that Partho Bhardwaj would be coming to Delhi in the third week of Delhi to collect the remaining balance of the security amount. Consequently, on 9th of April 2023, Partho Bhardwaj, his wife Mrs. Sudipta, and Nagappa Kurappan and B. also visited my place. I handed over case amount of the Vitna crore to Mr. Partho Bhardwaj, his wife Mrs. Sudipta. This amount was given in presence of Mr. Anand Kumar Srivastav, employee of Susila Gramodyog Limited. Mr. Partho Bhardwaj pointed out to me that amount was not actual due amount and he has issued the purchase orders of so and so. It was less than the demanded sum of 5% of the order place. I informed him that we needed more time to arrange for balance amount. The above-named persons persisted their demand for deposit of remaining liquidity for orders in case or that they are able to receive further supply of the ordered material and can proceed with payment of the supplied materials. Therefore, on their present demand, 24th April 2003, case amount of rupees 1 crore 50 lakhs was handed over to Nagappan Kurappan and V. Sivalasuru during our meeting held at Nehru Place in the office of National Federation of so and so and so and so, where they took me for getting the Messrs. POCSO International LLP registered with the so and so. This amount was given in presence of my driver Sanjay Kashyap. Mr. Susila Gramodyog Sansthan supplied materials worth rupees 3 crore and odd. Against the aforesaid orders, as detailed in the enclosed document, we approached Mr. Partho Bhardwaj and Nagappa Karwan to initiate payment for the supplied materials from the month of so and so, as per the order, terms of 45 days, enabling us to fulfill the supply requirement on time. Following persistent telephone calls, communications, Mr. Partho Bhardwaj and Nagappan Kurian of Susila Gramodyog Sanstha received a payment of 27 lakhs and odd from the Matak Council or any other account used by the accused, confirmed through so and so against invoice dated so and so, so and so and so and so. Now we don't. In total, sum of rupees 3,75,000 crores in case was received by the aforesaid accused persons in the name of security deposit and another 2.3 crores in the amount pending payment against the orders executed as detailed above. Therefore, the total amount to the tune of rupees to which the Susila Gramodyog was due by the accused person is 6.11 crores. Now, another aspect, he says that during the aforesaid period when Mrs. Gramodyog was due multiple times, I was made to book air tickets for the accused person to facilitate the finalization of the work, as detailed below and enclosed as Annexure 5. Now his contention is that on several times he booked my lord the flight tickets. My lord, the Matak Council is, my lord, situated at Dibrugarh. He said that there is another office at Gauhati. Goods has to be supplied to, my lord, the Matak Council, not in Assam itself. Now your lordship will find 12, 13, 14, 15, 16, 17, 18, 19 is in my name, my lord. He has given Delhi Bengaluru flight, Bengaluru Delhi, Hyderabad Delhi, Lucknow Bengaluru, Bengaluru Lucknow, Bengaluru Delhi. Twelve, 13, 14, 15, 16, 17, 18, and 19. These are the entries with regard to me, my lord. Then again, 27, so 27 also. इस पर लेकिन सबका है. Then 46, 47, 48, 52, 53. 52 to 60. Then 62, 64, 65, 66, 67, 68, 69, 70, 71, 72. And mostly all the tickets are for Hyderabad, Bengaluru, and all the rest places. Nothing to do with the subject matter. Page 107. Despite sending multiple letters to both the Matak Council of the Assam government, we have not received any response and acknowledgement in our communication. All communication details are enclosed. We have been consistently following up Mr. Partho Bharwaj, Mr. Nagappan, Courier Karappan to process the remaining amount. On Itna, Mr. Partho assured us that he would make remaining payment as soon as possible. However, subsequent to that, despite waiting for response, we have not received the communication response regarding payment. While awaiting his reply, we communicated to follow up their members, but unfortunately, we have not received any appropriate or definitive response which clearly discloses their ill intention and that they are systematically been involved in criminal breach of trust, cheating, amongst others, officers under penal code. Meanwhile, we got information that there has been a fraudulent activity under the guise of Matak Autonomous Council of Assam, perpetrated by a gang of 6 individuals, resulting in a fraud of 18.89 crores as reported in the newspaper. Such a huge outstanding amount has been criminally misappropriated. Upon inquiry, we discovered Mr. Parthos was the individual we were dealing with was arrested in Gujarat. Our further inquiry revealed that fraudulent activities conducted by the gang involving Ashish Bhai, Dhirajlal Desai, so and so, forming a highly the realization led us to conclude that this fraud group has been operating nationwide under the guise of Matak Autonomous Council of Assam government. Upon receiving the documents, similarly indicating that we have fallen victim of similar fraud. However, when attempt to contact Partho Bhardwaj, he has become unresponsive, further raising suspicions about the authenticity of dealing with him. Mr. Partho Bhardwaj, along with his associates, has intentionally formed an organization to receive the corrupt so and so and so. So, this is the basic, the entire allegation. From here, what I am trying to say, that there is no allegation that we cheated them. We were only liaising agent. And the person who was in the forefront, he has not been charged. That R.B. Thakur. Now, my lord, in this case, after investigation, charge sheet was filed on 20th of July 2024. My lord will find at page 109. My lord got it. My lord, it was on 20th of July 2024. My lord, I'm not. In the page 110, my lord, they have given the property description, seizure, and other thing. If need be, I'll come again. Your lordship will find at page 114. My lordship got it. Page 114, the parts of Haridwar. He was in custody at that point of time. Thereafter, from page 115 to my lord 118, my lord, there are 23 witnesses. Their name has been cited. And my lord, the facts, disclosure, and background of the case has been stated in page 128 onwards. But at this stage, I am not reading, my lord. I'm skipping. Only thing I would like to point out, basically the verbatim of the, my lord, FIR. What has been stated here in the facts disclosed, that has been stated. Now, at page your lordship will kindly come to page 131. Last part, serial number 20 in Roman. During investigation, it has been found that the letterheads, invoice, order sheet, seals, and other important documents were all forged and fabricated. The forgery was to such an extent that the name and other documents of Matak Autonomous Council, Government of Assam were freely and randomly used, and thus accused persons committed serious forgery, fraud, cheating, and impersonation, and criminal breach of trust. The complainant has been cheated to an amount of rupees so and so. It is pertinent to mention here that complainant has already paid in advance tax like GST and other things. Those are not relevant. Then my lord will kindly turn next page.
Yes. Yes.
My lord, at page 136, my lord.
136.
Yeah?
136.
The role of accused parts of her. In the page 16.8, my lord, in the middle.
Yes. Yes.
In the course of investigation of the case, it has been proved that alleged accused Partha Bharadwaj rest time was appointed as an advisor of Matak Autonomous Council by the existing council headed by so and so illegally without approval of the government of Assam. What I am trying to say, my lord, that if somebody has been appointed as an advisor on their own as a chairman, deputy chairman, well, people will definitely believe that he has been appointed. Whether that has been illegally appointed, whether there is an approval or not, nobody will go and see. Partha Bharadwaj may have committed offences, my lord. But so far, my lord, my client is concerned, the petitioner is here, my lord, he has no role in either forging the documents or in any manner, my lord, cheating or misappropriating the money in question. So, David agrees so and so Assam, who prepared false documents, using seal, stamp of the council and thereby order for supplying article of rupees 93 crore 68 lakh against the fake government scheme. The supplied articles of 3 crore so and so were received by a person, namely Khorgeswar Bhuiya, the manager of the warehouse established by Partha Bharadwaj, without the knowledge of the members of the council, but they paid only 74 lakhs and odd to the company against the supplied articles amounting to rupees 3 crore 10 lakhs. The rest amount was not paid to the company and thereby the accused Partha Bharadwaj committed cheating. Moreover, he put the signature of the principal secretary by himself, which was proved by expert by FSL Kahiripara. The alleged accused illegally opened a separate office for the Council of Ajantapad, Gauhati, and from that office he used to operate this scheme. In assistance with the other co-accused persons, he also created bank account against fake farm WPC something Carmack in the name of manager Minal Kumar Saikia, Rudrasagar Organic Farm in the name of his house cleaner Talukdar, and Rudrasagar in the name of his wife Sabjukta Sharma, and transacted money of the company using the said account. The alleged accused took a warehouse on rent, be appointed by the said manager of the warehouse located at Beharbari, Nalapara, Gauhati, who consignment of the article supplied to the company and complainant. The school bags and swimming machines were sold Nagaon, Morigaon, Hojai, Dibrugarh, Gwalpara through Dipankar Soikia, Suraj Jamal and others, and many others deposited the amount to the accused Partha Bharadwaj manager, namely Minal Kumar Soikia, house cleaner, Najbul Talukdar, and Mr. Sudipta Sharma, wife of Partha, which was operated by accused Partha Bharadwaj. Now, it's my duty to point out also, my lord, that there are 16.11 in page 137. Page 137, 16.11 paragraph. Further investigation, it has been found that remaining FIR accused persons and other accused persons are required, which is now under process. Some of the accused persons are yet to be arrested. Under the above facts and circumstances, the prayer is submitted before the Honorable Court to accept the charge sheet submitted against the accused, with the prayer to allow to continue further proceeding. Further investigation under section 173(8) of CRPC against the remaining FIR named accused persons and others to conclude the investigation of the instance case as early as possible. So, not the prayer was there. That's what I have pointed out to my lord. But my lord, no order has been passed by the the jurisdictional magistrate. Now, may I take your lordship to the order sheet? Well, in the meantime, let me see the second charge sheet also. Order. Page 334 onward. Page 334. Order है order. नहीं order नहीं है हाँ एक मिनट. My lordship got it. 334. Yes. My lord, on 29/7, after the filing of the charge sheet, my lordship got it. Yes. Case record containing charge sheet is put up so and so certificate enclosing 2 sketch maps, 4 certificates under to a banker's book of surveillance act, 1 seizure list, 2 certificates and so. These are things, my lord. I am not repeating. Then again, your lordship will turn next page, page 37, 335. Again, the charge sheet has been filed so and so and so. The records for the accused person is judicial custody in view of the materials available. Cognizance is taken under the section of offence as well as the aforesaid accused person. So cognizance was taken by this order 31/7. Then my lord will further find on that date 30th of August 2024. Copy has been, my lord, furnished. Copy was 38 2024. Copy was furnished to him. Then my lord can turn to next page 337. Order dated 25/9/2024.
Yes,
Accused,
30.
my lord, you got it.
Page 3.
Accused Partha Bharadwaj has been physically produced before this court. Copy has already been furnished to the accused person. I have heard both sides on the point of framing of charge and perused the case record. Considering the materials available on record after hearing both the sides, appears that prima facie case under so and so is made out as the accused persons. Accordingly, the charge are framed, read over, and explained to the accused Partha Bharadwaj. He pleaded not guilty and claimed to be tried. My lord, I am showing this for the purpose that after by framing of the charge, my lord, the trial begins.
Yes.
There are some other orders, my lord, it is not on here. My lord, the witnesses were called, they did not appear, so the matter could not proceed. But ultimately, my lord, on 13/12/2024, at page, your lordship will find page 151. One 50. 30 seconds, sir. I'm sorry, 139. I'm sorry, 139. It starts from 139. Page 139. This was on 13/12/2024. This charge sheet was against, your lordship will find at page 144. Karuppan Nagappan, this is one of the accused. Then your lordship will find page 144, Belappu Srinivasalu. 140, 145 minute, the petitioner before your lordship. So we have been charged under section 120B, 406, 417, 419, 420, 465, 467, 468, 471 IPC. And my lord, the witnesses, at page 146, your lordship will find the name of the witnesses. 13 witnesses has been cited for in support of the.
All this will come. You make submission why those 3 points you have raised.
My lord,
You have raised basically 3 points. Once 173(8), whether there was any order for. So on that point, what do you want to say? These are on merits, these are things and then.
not my lord, but I am trying to show, my lord. My submission is that 173(8).
Yes.
Although there is nothing written in 178, it says, your lordship, if your lordship will kindly have it, my lord. 173(8), I'll come. But I am trying to show, my lord, 3 aspects of the matter.
Yes.
CRPC, my lord, earlier.
Yes.
Mary. Nothing in this section shall be deemed to preclude further investigation in respect of an offence after report under subsection 2 has been forwarded to the magistrate. Whereupon such investigation, the officer in charge of the police station obtains further evidence. But this is important. The officer in charge of the police station obtains further evidence, oral or documentary. He shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed and the provisions of section 2 to 6. Subsection 2 to 6 shall, as far as may be, apply in relation to such report or reports as the case apply in relation to a report forward under section 2. What I'm trying to emphasize on that, my lord, that there must be, my lord, discovery of fresh material. On the basis of that only, he can file a, my lord, supplementary charge sheet. Though in section 173(8), there is nothing that they have to take without permission from the magistrate to make further investigation. Now, my lord, to buttress my argument, I have on the last occasion when the matter was there, I have given two charts, my lord.
Given two?
It is there, na? Why has it? No, why has it? I think it is there already. One is a statement of witnesses cited, and one is particulars of documents cited.
In one, some case laws are there.
The case law I'll come later. Case law I'll look at. Factually, I'm just case law I'll definitely. Hate to.
One is particulars of documents.
Yes, my lord, yes. If your lordship will kindly take it.
Which one? Particulars of documents or statement?
Documents I have not given because documents are not in my hand.
No.
Because
these are distinct. You have particulars.
These are my lord statement of witnesses. Which my lord.
No. The particulars of documents cited and relied upon in the second search sheet. You have submitted it.
My lord, what I am trying to show, my lord, that nothing, no new materials has been discovered after my lord filing of the charge sheet against my lord Parthabhar. If your lordship kindly take the first statement of witnesses cited, my lord, I have given. These are the, my lord, statements furnished to me by, my lord, as directed by this honorable court, because scanned copy was called for, my lord. So I was given the statement of witnesses of 15 persons. I have made a chart of that. My lord will kindly see name of the witnesses, type of evidence, page number and date of recording. If your lordship kindly look into that, all the recordings were made prior to 20th of July 2024 when the first charge sheet was filed.
First charge sheet was filed only against Bhardwaj.
Parthabhaj on 20th of July.
Yes, my lord.
No, only against Bhardwaj.
Yes, my lord.
Only against Bhardwaj.
My lords, may I just
Lord,
to assess the court only for a minute, my lord, on this point. Lords, why supplementary charge sheet came in, my lords, that's very important to mention at this point in time, my lords. Cut short the long story.
Lords, Partha was in custody, my lords. The charge sheet had to be filed in 90 days. The other co-accused, my lords, they were not within the police reach. They were filing their anticipatory bails, and they were later on clothed with the anticipatory bail order, my lords. My lords, only after the filing of the first charge sheet against Partha, these people came forward to the police agencies for investigation, and only thereafter charge sheet qua them were filed, my lords. My lords, I'm not able to follow, my lords. We are trying to turn the criminal law system on its head, my lords, without investigation. How could a charge sheet against these co-accused, especially the petitioner, could have been filed, my lords?
No, he is not on that. He is basically submitting that after filing of the charge sheet against Partha Bhardwaj.
Yes, my lords.
There was no fresh material or the new materials found.
Okay, lords, the fresh material is the state, my lords. The further investigation will have the material of the previous investigation plus the statements of the these accused, my lords.
No. His submission is that after filing of the first charge sheet against the Partha Bhardwaj,
Milords,
there is no materials found.
Milords, Milords, if supplementary charge sheet would have been qua this present Partha. Milords, this supplementary charge sheet is not qua Partha. Milords, what judgment had been referred was with relation to if supplementary charge sheet qua the person against whom first charge sheet was filed. This is not the case, my lords.
No. This is not the case.
Yes, my lords, that's not the case.
I am not arguing on that, my lord. Understood, my lord, I know, my lord.
Yes.
My whole submission that me to the law. My lord, I am not on that, my lord. Whether I have committed the offence or not committed the offence will be a secondary question. That my lord will look into it. Or my lord may say that no, will not look into this. But my submission is that 173(8) permit further investigation. But I am not saying that is bar. In this section itself, no permission is even required. But the case law, that has been developed, by the apex court says that no, permission is required. Latest decision, which I have not cited on other day, I found other day, is by my lord Justice Vinod Chandan and my lord Justice Bisnoy, who was my lord Chief Justice of our High Court. Their decision is very clear on this. First aspect is that no fresh material was there. So what stopped you from filing a charge sheet on that day when you filed charge sheet against the Partha Bhardwaj? Where was the question of further investigation? Because the law says that you have to find out further materials. Further investigation means to find out further materials against the people. Nothing has been brought on record. That's what I have given a chart. Interrogating the accused has nothing to do with it. The statement of the accused is also there. I have enclosed because that was furnished to me, my lord, at page 24. So this is one aspect of the matter. Then my lord will kindly see the other chart. That is, my lord, particulars of documents cited. So document page is document नहीं किया.
Yes.
My lord, your lordship will kindly see first is the FIR that is there. Certificate of registration, my lord, it is a registration in the name of Susila, nothing to do with my lord, any allegation. Third is original letter of procurement of beneficiary item from so and so. There is nothing. One original copy of memorandum of understanding is signed on 2nd February between Matok Autonomous Council, Dibrugarh. That was my lord, Partha Bhardwaj signed. One original letter of award for procurement of beneficiary, my lord, that was also signed by my lord Partha Bhardwaj as a principal secretary. 2/5, 2/6, all are my lord these. 2/7, 2/8, 2/9, all these, my lord, they have then certified tax invoices. 2/11, sketch map of Matak Out of Council Office 3. 4, sketch map of so and so. Certificate under section 65 of the evidence against CDR and CF of mobile number. Because they traced me, lord, some whether I was at Dibrugarh or not, whether I was at Gauhati or not, They traced and they found that my mobile number was there. So that is a certificate to that effect. 5 and 6. 7 is a certificate in respect of screenshot of mobile WhatsApp message, ledger copy along with the bank statement. These materials, my lord, your lordship will find, I have given in this serial number, the charge sheet of Partha. These materials were already available. In column, fourth column, my lord, serial number in charge sheet against Partha was first charge sheet. Your lordship will find I have given this serial number against the serial number. I have mentioned everything. So these all materials were available at that point of time. And my lord, your lordship will find from these documentary evidence, no material is there that I forced, because that was sent for my lord forensic examination. If your lordship, again, if I take back your lordship to the first charge sheet, your lordship will find that forensic report is there. So far as against my lord Partha Bhardwaj is there. My lord, I was taking my note to the additional charge sheet filed on 13/12/2024 at page 151 onwards, my lord. 131. 130. Yeah. My lord, the chart has been prepared on the basis of the charge sheet, my lord. My lord, if your lordship feels, your lordship can also, my lord, tell you that. Well, the facts has been given, my lord. I am not reading the facts. Now, after filing this additional charge sheet, there is again another charge sheet was filed, where I am not involved, but in this their charge sheet was filed. I think, my lord, sometime एक और charge sheet filed हुआ है. Now, so far this charge sheet is concerned, my lord will kindly come to page 338. Page 338, my lord, order dated 3/1/2025. Additional charge sheet along with the documents in continuation of CIDPS has been submitted by IO. But I am not reading the entire. Accordingly, cognizance of offence under section so and so has been taken against the accused person so and so and so and so. And issue summons to the accused person for protection so and so and so and so. These are not relevant. So what I am trying to show from that, cognizance was taken against that. I have challenged the cognizance also. This order. Charge sheet taking cognizance by order dated 3/1/2025. In the meantime, my lord, since, my lord, there was no stay, my lord, I received summons. So, my lord, ultimately on 26 to, my lord, I entered appears before the honorable court, before the trial. Now my lord, now the matter is pending for, my lord, giving copies and other things. It has not proceeded any further, and tomorrow is the date fixed, my lord. So, my lord, I have three contentions here. First, my lord, I have shown no fresh materials. Second contention, my lord, that already charge has been framed against Partha Bhardwaj. So, the apex court and your lordship has also, this court also held that once charge is framed, the trial begins. Not prior to that. Prior to that, the stage is inquiry. Investigation, inquiry, and their trial. Thirdly, from the materials on record, I have shown that there was no permission from the Honorable Court, though prayer was made in the charge sheet itself. Now, may I, so far this contention is concerned, may I take to your lordship to the judgments? उसका कॉपी दिया हुआ है वो और दे देगा लेटेस्ट वाला भी हमारा फाइल देना तो हमारा तो ये है latest वाला दे देगा latest वाला the earlier decision I have already given. I'll refer to that, but before that I'll read the latest decision on this. 2026 SCC Online 156. Oh, I'm sorry, not Chandan. Rajesh Bindal versus Vijay Biswal. Not
You are emphasizing on para?
Lord,
Paras, which are emphasizing.
para, I'll be referring to. But your lordship will kindly see. Para, after para 6 minutes, I'll not read the entire, I'll just give the gist of that. After completion of the investigation has submitted a final report, so and so. It says that no offense was made out against the accused persons, including the appellate hearing, in the light of contradictions between the statement of original complainant, so and so. After receiving the closure report, the court of first judge Faizabad issued several notices to the original complainant. However, despite service of notice, neither they appeared before the court nor filed any protest petition against the court. The court first additional district judge Faizabad, after considering the closure report, has accepted the same. I ordered it, noting that the materials on record do not support the prosecution. Subsequently, after the span of about 3 years, the original complainant filed a criminal division petition before the Court of District and Session Judge Faizabad for setting aside the aforesaid order, wherein the closure report was accepted. The case was presently pending before the Court of District. Thereafter, Mr. 1 Anshu Kumar filed a complaint before the National Human Rights Commission, alleging several deficiencies in the investigation conducted by police. I'm leaving that ultimately, in compliance thereof, there was a direction to in compliance thereof, the Undersecretary Government of Uttar Pradesh forwarded a communication dated to the Director Crime Branch Crime Investigation Department Uttar Pradesh, informing that in pursuance to the direction of NHRC, it has been decided the matter should be investigated by CBCID and further directing it to complete the investigation within a period of 6 weeks and submit a final progress report. In view of the aforesaid, the Undersecretary Government of Uttar Pradesh, by later dated so and so, informed the NRC that an investigation pursuant to the conduct of the officers involved in the present case is underway. Further, it was informed that in order to reveal the truth of the accusation involved in the case, it recommended, your lordship will kindly see, this is important. It recommended that further investigation under section 173(8) should be conducted in FIR number so and so. With the approval of the Director of Police, an inspector was nominated for carrying out further investigation of the present case under section 173 of the CRP. Pursuantly, the newly appointed IO filed an application dated so and so before the Court of First Additional Civil Judge Faizabad, seeking permission to conduct further investigation in the task case under section 170. Thereafter, had communication dated so and so, the Superintendent of Police Agra informed the Additional Superintendent of Police about the nomination of the IO in the present case and also directed him to make available the special report relating to further investigation, the draft of the plan and the monthly progress report in prescribed formats to the headquarters on time, and complete the investigation as soon as possible and send the file progress to the headquarters. In furtherance of the said investigation, the IO sent a notice to the accused persons, including the appearance, for the collection of their blood samples to conduct DNA tests, and blood samples were collected. Consequently, the appellant filed criminal misdeed petition before the High Court challenging communication dated so and so and order dated so and so. Because that direction of further investigation, that was challenged. The High Court, by order dated, initially granted interim protection from arrest to the appellant. However, in the same order, it was directed that investigation continue and that the appellant will cooperate with the investigation. During the pendency of the petition, the Director of Forensic Science, Liberty Uttar Pradesh, submitted DNA report stating that the accused persons, including appellants, were not the biological father of the fetus of the prosecutrix. Later, the High Court, by the impugn judgment, observed that in allegation of rape were made against several and the prosecutor also filed a protest petition against the final report submitted by the investigation officer. The DNA sample of the aborted fetus resulting from the pregnancy from alleged rape was also preserved, and the investigation officer returned to the court saying the DNA test to be carried out to ascertain who was involved among the several accused. In the commission, the High Court thus held that it found no good ground to entertain the petition and dismiss the same. Aggrieved the appellant before the instant appeal before the court during the pendency of the court by order dated issued notice and state obsession of the communication dated 6/6 and order dated 26/4. That was state, that communication for further investigation. Now, contentions of parties, right? पैरा 22 से स्टार्ट होगा 22 पेज Mr. So-and-so submitted that the Superintendent of Police Agra, on recommendation of the State of Uttar Pradesh, was directed to further investigate so-and-so without obtaining prior permission from the competent court. Even though a closure report has already been accepted, the learned counsel for the appearance contended that once the final report is accepted, only the criminal court has the power to order further investigation. As such, power cannot be exercised by the police or any executive authority further. The so-called further investigation is in fact an impermissible de novo or fresh investigation. It is ordered after about 7 years without any new additional materials and was initiated from the very so. The learned counsel for the appearance further contended. But I'm not reading the entire. The Vinay Tyagi has been cited. 2013-5 that has already been referred by me earlier. I'll read that judgment, wherein it was held that a part is held. It is the part of the procedure of the investigation agency to seek leave of the court before conducting further investigation. Now, analysis. Next page is para 27. The 173.8 has been quoted. Para 28. Thus, the power of investigating agencies for further investigation are not in dispute herein. However, what catches attention here, which is also crux of the controversy in the present case, is which authority can pass an order directing investigating agencies to undertake further investigation under Section 173(8) CRPC. The issue regarding the procedure to be followed for directing further investigation in a case has been dealt by this court in case of Vinay Tyagi, wherein this court, while dealing with the contours of Section 173 CRPC relating to further investigation, pronounced that the police ought to have followed the procedure of seeking permission from the court to conduct further investigation to file a supplementary charge sheet. The relevant paragraphs from the judgment are reproduced herein. Then 40.2 magistrate, that has been quoted. A magistrate has the power to direct further investigation after filing a police report in terms of Section 173(6) of the court. Then para 30 that has been quoted, para 30. In this very judgment, this court, while noting that although there is no explicit mandate under Section 173(8) of CRPC to seek leave of the court before conducting further investigation, nevertheless, over the time, a practice has been developed to seek permission of the court. Therefore, the practice to seek leave of the court will have to be read into the provisions of Section 173(8) CRPC. But it is not there. It said that it has to be read into it. And it is essentially a prerequisite for directing further investigation. This court therein held as follows. Now we may examine another significant aspect, which is how the provisions of section has been understood and applied by the courts and investigation. It is true that though there is no specific requirement in the provisions of section 170 to conduct further or file supplementary report, with leave of the court, the investigation agency have not only understood but also adopted to a legal practice to seek permission of the court to conduct further investigation and file supplementary report with the leave of the court. This court in some of the decisions has also taken a similar view. The requirement of seeking over leave of the court to conduct further investigation or file a supplementary report will have to be read into, and it is necessary implication of the provisions of section 173 of the code. The doctrine of contemporanea exposito will fully come to aid of such interpretation as the matters which are understood and implemented for a long time, and such practice that is supported by law should be accepted as a part of the interpretation. Now, para 31. The proposition of law laid down in this case of Binay Tyagi has been further affirmed by the three judges bench of the court in case of Binu Bhai Hari Bhai. Well, that decision I have already given, my lord, there. This court has dealt with a similar situation in a case of Pithambaram versus State of Kerala. My lord, that also is already given, my lord, the citation. When the district police chief, superintendent of police ordered further investigation. This court therein, while passing the order passed by the district police and there the power to order further arrest either with the magistrate concerned or a higher court, but not with the investigation agency. The relevant paragraphs from the judgment are reproduced as follows. The chief police officer of a district is the superintendent of police, who is an officer of the Indian Police Service. Needless to state, an order from the district police chief is not the same as an order issued by the magistrate concerned. Referring to Vinay Tyagi, this court in Devendranath Singh versus Sanso noted that there are no specific requirement to seek leave of the court for further investigation or to file a supplementary report, but the investigation agency have not only understood it to so, but have also adapted the same as a legal requirement. The doctrine of so and so is the same thing which has been said. Now, para 33. In the light of the legal position as settled by this court through above judgments, it is safe to say that the power to direct further investigation in a case rests solely at the discretion of the magistrate or court concerned. In the event the police investigating agency is of the opinion that further investigation is necessary in any particular case to call out complete facts and truth in the case, it is binding upon them to file an appropriate application before the magistrate court without directing an order for further investigation by themselves. Once such an application is filed by the investigating agency, the magistrate would, this is very important, apply its judicial mind in the light of the facts and circumstances of a particular case and reasons demonstrated by the investigating agency in order to exercise its discretion for exercise of its power to decide whether or not further investigation is to be ordered under the purview of section 173. That's what I pointed out, that though there is a fair formula. And in fact, there is an application file also. You will also be in para 34. If your lordship kindly come to the present case, the Undersecretary of the State so conductor says this Undersecretary also recommended further investigation. So his letter addressed to so consequently the investigating officer of the CBD wrote a letter to the judicial magistrate Firoozabad requesting to grant permission to conduct further investigation under one and provided a copy of the diary. However, the court did not pass any order to the extent of requisitioning the investigation to conduct further investigation. Para 30. Thus, it is amply clear that Superintendent of Police acted in complete defiance of the procedure laid down under the law while passing order directing further investigation without seeking leave of the court. It is an unbecoming conduct from the officer of such a rank to exercise unfettered power in excess of his jurisdiction, thereby undermining the authority vested in the court of law. Now, we on the other decision.
Five other judgments you have signed.
You know?
5 other judgments you have.
These are from 79 onwards, my lord. And my lord, your lordship will find the third, Binu Bhai.
Yes.
That was a larger bench decision, my lord, after Binay Tyagi. And that has approved Binay Tyagi another decision. Thereafter, my lord, I have given 2024-16 SCC. This is the latest 2004-11 SCC. You know, these are the latest, and then latest one that I have given to your lord. No, भाई मैं देखो, no, भाई मैं in Binu Bhai, my lord, Ramlal Narang has also been, my lord. If your lordship kindly turn to the third flag, my lord.
Yes, start.
There are 20 of that.
There are 20.
There are 20. I'm just showing one thing because that was with the introduction of section 173(8) in CRPC, the police department has been armed with the powers of further investigate an offence, even after a police report has been forwarded to the magistrate. You know, that I have read. Quite obviously, this power continues until the trial can be said to commence in a criminal case. But in our case, the trial already commenced, my lord. Then para 29, Ramlal Narang has been, my lord, quoted. Then my lord will kindly come to the para 31. It says that it is an important judgment which deals with necessity of further being balanced with the delaying the principle. If there is necessity of when fresh facts come to the light. That was on different aspect because the question was raised that there is a delay. But one thing then my lord Vinay Tyagi has been also referred. I will come directly to para 38, my lord. These things.
Vinay Tyagi, para 38.
Para 38, my lord, only one thing I am pointing out. Para quoted Common Cause Case versus Union of India. In cases of trials before session court, and the trial shall be greeted to have comments when charges are framed under section 220 of the in this case concerned. But that was a case of second part. First is session judge, second is my lord. Police report, such trial shall be treated to have comments when charges are framed against the accused person under section 246 of the Code of Criminal Procedure. This is one of the submissions. Lord, may I take to paragraph 42, my lord? This is important. I'll read this part. That has been also earlier quoted. There is no good reason. May I read, my lord?
Yes.
Why? Para 42 is page 39.
Hmm.
There is no good reason given by the court in this decision as to why magistrate's powers to other further investigation would suddenly cease upon process being issued and accused appearing before the magistrate, while concomitantly the power of police to further investigate the offence continues right till the stage of trial commences. I'm emphasizing on that, my lord. Such a view would not accord with the earlier judgments of this court, particularly so and so, having clearly held that criminal trial does not begin after cognizance is taken, but only after charges are framed. But he is not given an important at all is in the recent judgment of this Court of Constitution that fact that so and so fair investigation, to say that fair investigation would lead to conclusion that the police retain the power, subject of course to the magistrate's note under section 178(3) to further investigation offence till charges are framed. But that the supervisory jurisdiction of the magistrate suddenly ceases midway, so the pre-trial proceeding would amount to a traversy of justice, as is not wrongly arraigned as an accused or that prima facie guilty person is not left out. There is no warrant for such narrow and restrictive view of the power of magistrate, particularly when such power is traceable to 156 3 read with section 156 and 2H and section 177 as has been noticed herein above and would be available at all stage of the progress of a criminal case before trial actually commences. It would also be in the interest of justice that his power to be exercised promoted by the magistrate himself depending on the facts of the case. Whether further investigation should or should not be ordered is within the discretion of the learned magistrate, who will exercise such discretion on the facts of each case in accordance with law. In the next case also in para 28 the same has been held. Para 28 of the next case, next place, that is Pithambaran versus State of Kerala. Now that has been referred to in the last decision which I have. अभी तो दिक्कत होगी right. Well, I'll just cite the last decision of 2004-11 SCC 733. I have given the paragraph on the top sheet which will make convenient for my lord to find. I'll read para 38 and 39 of the last decision that is already given my lord, that Mariam Fasiuddin versus State of Karnataka. It is a matter of record. My lord got it. Para 38. It is a matter of record that course of further investigation, no new material was unearthed by the investigation. What was the third question? Because I have satisfied on the two questions. The third question here, it has been dealt. The supplementary charge sheet relies upon the truth lab report dated so and so obtained by respondent to which was already available when the original charge sheet was filed. The term further investigation is stipulated in section 173(8) CRPC obligates the officer in charge of the police station concerned to obtain further evidence or oral document. In my case, my lord, I have given the chart, I have shown that no further materials has been done. My lord, by merely, my lord, interrogating the accused has nothing to, my lord, accused will never say, my lord, that no, I have committed the offenses. They have to get the materials to prove the case. Nothing is there. And only then forward a supplementary report regarding such evidence in the prescribed form. The provisions of submitting a supplementary report interfaces that fresh oral or evidence should be obtained rather than re-evaluating or necessitating reassessing the materials already collected and considered by the investigation while submitting the initial police report known as the charge sheet and so and so. In the absence of any new evidence found to substantiate the conclusion drawn by the investigating officer in the supplementary report, a judicial magistrate is not compelled to take cognizance. As such, a report lacks investigative rigor and fails to satisfy the requisite of section 173. What becomes apparent from the facts of record of this case that the investigating agency acted mechanically in purported compliance of the trial magistrate's order. In this case, there was an order of the trial magistrate. But in our case, that is not there. But in spite of that also, my submission is just nothing material, no material was found out. So what stopped them to file a charge sheet against us at that point of time? So time will not permit further. So far, my lord, 173(8) is concerned, my lord, I have shown all the materials. But the next argument is that whether, if your lordship accepts this, then my lord, I need not go to the other portion. Well, because passing of the charges, because no material has been placed.
It is your case that no material has been placed at the time of the further investigation of the matter. There was no fresh material to file the subsequent or the second charge
No, my lord.
against your petition.
That is another one
That is
aspect
your
of it.
case.
One aspect. No, the second aspect is the matter, my lord, that even if your lordship looks into the entire material,
In that case, also there
whether
is no material.
I have committed any forgery, I have committed any cheating, because my lord, I have not done anything, your lordship will find. The evidence of the witnesses will also show. A money transaction, my lord, at this stage, my lord, I am not disputing, because there is some dispute, but that will be in the course of trial. They say that 1 crore 50 crore was given in my hand at Delhi. Well, it is not the case that, my lord, I have misappropriated it or I have not given it to, because that money was given by, my lord, the Susila Gramodyog for the purpose of sending it to Mr. Partho Bharadwaj, as per their understanding of 5% commission in that. My lord, the mastermind was Partho Bharadwaj. And my lord, your lordship will kindly see in this entire case, the chairman and other persons of the matter council has not been brought into court. Rather, one of the witnesses says that the order was passed, maybe illegally, maybe without sanction of the government. But people will believe, my lord.
Do you want to continue further? Your part remain closed, or you want to
My lord,
continue
if
further?
that part your lordship is not hearing, then my lord, so far 173(8) is concerned, my part is closed.
No, what is the other part you're saying?
Other part is that, my lord, passing of the petition, even of the materials are, even if reading of them, I have been charged. That is the second part, and for that some decisions are there.
So you have completed your part, there is 173(8) only. The rest part, there is no material against you to even to proceed with the case. So quashing is who is that? Depends. Obviously, time may not permit.
Time, my lord, do not permit. My friend is also from Delhi. Yes.
Oh, you're from Delhi.
Milords, I've already missed my flight.
He booked a flight asking me
Because
that.
I thought, Milords, I had gone by the serial number, so I thought probably before lunch we could start. But anyway, Milords, I'm at Milords Mills.
In that case, are you going to stay tomorrow? Or
No, Milords, I have some very important issues tomorrow, Milords, for the Delhi High Court.
Oh,
if we make it as a supposed part, then it would. But you tell from your side, your convenience will consider.
Pardon me, Lord?
Will consider your convenience. What it will convenient date for you.
So I'm really grateful, Milord. Milords, we want to have it in May or in July, Milords.
June, you have something else?
So June is holidays in Delhi High Court, Milords, and my daughter is in the US, Milords. And she hasn't come for a year.
July we have
because
holidays.
Donald Trump doesn't allow children to travel back.
July we have holidays up to, my lord, yeah, I think 11th.
July
11th.
So it's because you never know if she can go back. That's the reason she's not coming. The way that gentleman is behaving.
आपका प्रॉब्लम है क्या बोल रहे हैं आप
6 July is अच्छा sorry
14th डायरी हमारा डायरी पर किताब के साथ डायरी पर कोई दिक्कत नहीं सुनने के साथ साथ लीजिए तो लंबा नहीं होगा 14 जुलाई 13 मत रखिए हियरिंग के रखिए 13 14 दोनों रख लो मौसम डे रहता है।
अच्छा हाँ सो ट्यूसडे या थर्सडे
आप जैसे बोलोगे,
14th
आप जैसे बोलोगे
14th and 15th.
विल कंटिन्यू नो प्रॉब्लम।
Let's say, can it be 14th and 15th so that we can conclude, you know, if my learned senior takes more time?
In which month? This month?
No,
July,
July.
July?
Yes, my lords.
No, no, I have no problem, my lord. I am in May, my lord. I am available in 3 dates only, 25, 28 and 29.
You will not be available.
But on 25th, 28th and 29th, I am available. In
That's the only day that's available to him.
That's the only day you are available.
That's it.
Because we have checked this one. There are lots of hearing matters have already been fixed. We want to fix it in a hearing day so that because
No, my lord,
the other
let
day
it-
the motion
my lord,
and
my
matters
friend is expressing his difficulty, my lord. I can't oppose because he is in June. He is going to US to meet his daughter and all, my lord. So it's difficult on my part to
July,
say.
our reopening day is on
He says 14th of July.
Our reopening is on 13th.
Our reopening is 13th.
Yes, my lords.
14th ki bar?
Tuesday.
Mangalbar.
Tuesday.
Then
Tuesday,
14 is
Tuesday.
14 is
Tuesday.
Tuesday.
Yes, my lords.
At 2 we'll fix at 2 p.m.
Fine, my lords.
Because otherwise, because what has happened in the hearing day, there are many matters.
Well, yes, you're right. At 2 p.m.
In
At 2
January
p.m.
fixed.
It
so
will be
if
better
we
for me
fix it
also.
to- Then obviously this matter will be taken at
At 2 p.m.
And then if in that case, suppose in 14 we could not complete the matter,
Lord, we'll
if you cannot.
spill over on
In
that.
that case, it will be on either for your
the next
convenience,
day.
we'll fixing on the next.
Fine.
So that this time we should finish it, my lord.
Yes, this time.
And my lords may just mention in the order sheet, my lords, at 2 p.m. my lords, please.
I will mention it
Yes, my lords.
so that the registry can
Yes.
fix it. Up.
Yes, yes.
My lord, only one difficulty, my lord. I am, my lord, without any stay is there, my lord. No stay is there. So I have already appeared before the trial court.
No, they are already on bail, so what do
No,
they have to
bail,
worry?
bail is no difficulty, my lord. If the court proceeds and frame charges, my entire petition will be infructuous.
Okay.
That's the only difficulty. Otherwise, I have already appeared, my lord, because I know that, my lord, the matter is being delayed and all that. So some protection.
No, from our side too, we may fix around 26th of this month, May. If we are agreeable to this, then we can fix it on 26th.
No, 26th, I'll be not.
26th of this month.
I'll be not there. I'll just check.
27th is a holiday. 27th is a holiday. 26th to he has to the 26th is not holiday.
Again, 27th is holiday.
Yes, 27th is a holiday.
28th.
ठीक है, यदि होगा, है क्या? Possible है? Possible है?
Let's have it in, if it, as per my lord's convenience, in July only, my lords. 14th and 15th.
14 at 2 p.m.
At 2
Part
p.m.
heard. It will remain as a part heard at 2 p.m. Then it will come on, then the other matters may be adjourned. Your matter will
Only
be
whether, my lord, my one prayer is there, subject to what my lord, only one thing that, my lord, the court will proceed with the matter, but will not frame the charges, my lord.
Then not frame the charges.
Because, my lord, if
Oh,
charge is framed, my lord, my whole, because my entire case will go, my lord. So, this is only my, yeah, my lord, less, I leave to my lord. Let the copies, tomorrow is the date fixed for copies and other things. So let me proceed. I don't say that they should be stopped and all that. And they should proceed. Only thing that, my lord,
charge hearing.
that will, your lordship will kindly take into consideration and further.
Part of considering the submission by the learned senior counsel. The learned trial court below is hereby directed not to proceed with the case further, but not to take the not to record the charge hearing of the charge frame.
My lord, in this matter,
Not to proceed with the not to proceed with no as yet sorry as so and so the planet court below is hereby directed to proceed with the case as further as there is no stage operating. However, charge hearing may not be considered at this stage until further.
Lord may not stay, Lord may say that order may on charge may not be passed till the petition is heard, Lord. That's all.
Otherwise, the framing of other copies and all these
Lord,
things.
the others can continue. Let them not,
I'm also Charles here.
let them not frame the, or not pass a order on charge. That's all. Not stay the proceedings.
I'm not saying for staying of the
Yes,
proceedings.
I'm
It was on a very lighter note.
Specifically, I have emphasizing that the case will be proceed further as there is no stay is operating. However, court will not frame charge till a further order.
Yeah, that will do. That will do. That will. I'm obliged.
Yes, POCSO, what?
No, my lord, only that part. Already, my lord had, my lord, this passed that order. Because, my lord, this is a case of, my lord, Motok Autonomous Council. Already, my lord, where, my lord, that a serious fraud was taken part. And, my lord, though, my lord, the 2 numbers of surcease is, my lord, filed, only my learned senior contention is that when, my lord, that admittedly, in the first surcease, my lord, that line is there, my lord, the permission for the supplementary surcease. When the supplementary surcease is filed, my lord, that is the contention is made that, my lord, in the second surcease, my lord, no, my lord, additional, my lord, that is the documents or evidences come out, my lord. That is the submission. That is the technical job. And, my lord, in that case, my lord, the third submission of my learned senior is that if it is so, there must be a, my lord, that is a, my lord, the permission from the learned trial court. That is the thing. Now, my lord, what
does not say so.
Yes, my lord. Now, my lord, my limited understanding of the law is that, my lord, when, my lord, there is a, my lord, the first surcease, my lord, and it is, my lord, filed the second after 2 months, my lord. The when, my lord, the first surcease is filed and when there is a, my lord, prayer, it means that, my lord, there is a tacit, my lord. The tacit, my lord, there is permission was there. Because, my lord, whenever it is, my lord, that is admitted, it is admitted in full, my lord. Secondly, my lord, now the only the technical part is that, my lord. When, my lord, it is, my lord, that the statute say it cannot preclude, my lord. The word is there, is that it cannot preclude, my lord. That is for the regarding the supplementary surcease. Now, my lord, whenever we go through the, my lord, that it is the facts of the case. What is the case? The case is regarding some monetary transaction. Number 1, on the face of some, my lord, the producing of the fake document. Now, my lord, who am I, my lord? Who is coming for the, my lord, that is, my lord, taken his, my lord, name away from the surcease? He is a person. He said that I don't know that I know the one person who is a Mr. Bharadwaj. He is a, my lord, authentic person. I understand. But does it mean, my lord, what is in the investigation that I am a person, my lord, X, who knows Mr. A is an authentic person, that the whether, my lord, A can confer me the power or the right so that I can go, I can sit with the person and take the money from on behalf of an institution. These are the part, and these are the, my lord, matters of record which will come into the trial, my lord. It is not just because of the documentary evidences and, my lord, investigating agency, my lord. What my limited understanding is that, my lord, in those cases, they are taking time to find out the money trail, whether other persons are also, my lord, involving in those matters. So, my lord, that is my humble submission, as because already, my lord, had said that there is no stay in the path. Only, my lord, that is, my lord, till date, my lord, that is the search from the party. So, my lord, that will be.
Otherwise,
One on a very important note, my lord, I just wanted to supplement what the learned prosecutor said, my lord, and very wisely he said, my lord, with full of wisdom. My lord, if for a moment, my lord, we were to accept that a charge sheet is filed against one accused who came forward, my lord, and investigated. Lord, it is going to turn the entire criminal law on its head if this proposition is accepted of the learned senior counsel, my lords. Because what in a normal course, my lords, Dawood Abraham, after committing in 93, he evades arrest for 1 year. Charge sheet is filed quad 2 accused, and he comes forward. He says the charges have been framed. Now, don't, my lords, what all judgments have been shown is quad the accused who have already been charge sheeted. There is not even a single judgment where a fresh charge, supplementary charge sheet has been filed against an accused who's not there in the earlier charge sheet. Beloved, see what the Supreme Court has already said, and beloved, I'll read from Ramlal's every judgment. It is the prerogative of the investigating agency for further investigation, and whether to accept or not to accept is the domain of the magistrate, my lords. Whatever all time they say that the higher court should not interfere in that. What all judgments which my learned senior has shown, my lords, it's the ones, those accused against whom charge sheet was filed, and then further investigation. Because what this, my lords, in this very interesting aspect, my lords, had that charge sheet been filed against Partha, this fellow, the petitioner today, they would have come with a petition that without investigating us, without taking our view, they have filed a charge sheet against us, my lord. What is the fairness in that? That they recorded their statement, they confronted them, and only then, subsequently, they filed the charge sheet. What wrong has the police done in this, Milords? I'm highly grateful. Milords, if we can have it in May 25th, Milords, if 26th, can we have it on 26th?
July.
No, 24th. No, Monday is 24th.
No, 25th May.
Sorry, 25th.
26 I will not have it.
Okay, 25th, you are there?
26th.
लेकिन एक दिन होगा नहीं फिर क्या फायदा 25th is a motion day, it will not be possible.
26th.
Motion day it will not be.
Not possible, I know. Today also I am sitting, Your Lordship.
Condition. 63, 64 matter. has
Let it
been
let it
listed.
be on
So,
July, no, there is no possibility.
apart from that, probably about 15 or 35 or 40 matters, bail matters have been listed. So,
So Milords is going to keep it part heard, Milords.
yeah.
Yes, Milords. Fine, Milords.
Let it be.
Because I'm fixing Act 2, so that it can be heard. Otherwise, it may
Means all
get-
the, Milords, all the judgments are qua the accused,
But
against
let
whom
him
charge
make-
sheet was filed, and then further investigation has taken place, Milords. Milords, very misleading judgments, Milords.
Let's see.
I'm highly grateful, Milords.
Yes, at best I can give you a date. Yes, when it can be. You're not going to hear.
Yes, today not possible, my lord. Any date, my lord.
Better to take in a hearing day because motion day you see the condition. Obviously, there are some admission matters in the motion day also, no issue and that.
Yes, my lordship convenience, my lord. Any date may be fixed, my lord.
4th of June. He's saying 4th of June.
My lord. There is an interim, my lord, that may be continued.
Interim was day.
My lord.
Interim be continued till next date. Listing due to paucity of time. So we're listing it on 4th of June in admission column. Yes, yes, Mr. Chaudhary.
24, Lordship.
Hi.
Item number 24, Lordship. Last two occasions, Lordship, report was called for from the IO.
In regards to?
Regarding Lordship, Jimma of vehicle, Lordship.
Okay.
That's 24.
Yes, Mr. Bush, in 24, there were reports were called for.
My lord.
Item number 20.
Report to review.
Have you received?
Jimma of vehicle. No, it was not. Special part. Case number.
That report, my lord, we cannot receive.
Not yet.
Yes, my lord,
Item 24.
yes, 24.
Item 24.
Yes, but one report, my lord, we have received, my lord. That is, my lord, in this regard, my lord.
No, we're not going to see report received.
Yes, my lord.
Okay.
24.
Okay, then we'll list it. We'll try to give a short date.
Lordship.
My lord.
2/8. Short date is 2 days. I don't know. Apart from that, we don't have.
18 if possible, Lordship.
Huh?
18.
18, no, not possible. My
28.
matters have already been fixed. At best 25. 25.
Lordship, 25. Lordship.
List on 24.
Deeply obliged.
Because report we have already received.
25.
Produced the report.
Report to us.
आपके orders भी लग- The other order matters have been deferred. All
Right.
other order matters. We'll try to give a convenient. All the matters have been deferred. Definitely it will be adjusted